it stops, no one knows. We're going head into the unknown. Na, 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 na.
All right. Well, good morning, ladies and gentlemen. We are on the record back on State of Indiana versus Richard Allen. I'll show the defendant is here in person with counsel, Mr. Rosie, Miss Auger, and Mr. Baldwin. The state is here by Mr. McClelland, Mr. Latrell, and Miss Diener. And which motion to suppress are we going to start with? Are we doing the second statement or the motion to suppress, Mr. Rosie?
May I, Judge?
Yes.
In consultation with our team over last night and this morning, we are moving to withdraw the motion to suppress Mr. Allen's second statement to law enforcement. So that issue will not be addressed today, which leaves us with the other regarding incriminating statements.
Okay.
Thank you.
All right. So that was the motion to suppress accused's second statement that was filed with the court on April 15th, and that is being withdrawn by counsel.
Yes, Your Honor. Thank you.
All right. Well, thank you then. We are proceeding on the motion to suppress filed April 11th of 2024. All right. You may proceed.
Judge, would the court appreciate some type of opening or waiving that, or do you want to just get right into evidence?
No, go right ahead.
I know Judge have different opinions about those kinds of things.
Go right ahead.
All right. The motion itself is intended to address the issue of incriminating statements that were made by Mr. Allen while he's been housed at the Department of Corrections. Basically, we're here on some constitutional law issues today, which I have acknowledged in the past to some of my colleagues is not my strength, but I feel like I'm pretty versed on what's going on with Mr. Allen's detention circumstances, and what you're going to hear today is that there are several different amendments that apply. The first one, which is identified in our motion, is the Fifth Amendment, his right against self-incrimination, which is also joined by Article 1, Section 14 of the Indiana Constitution. The Sixth Amendment, his right to counsel, which is paired with Article 1, Section 13 of the Indiana Constitution. The 14th Amendment, Due Process Clause of the United States Constitution, which is paired with Article 1, Section 12 of the Indiana Constitution. And there's a sprinkling, so to speak, of the Eighth Amendment in this scenario, which is the federal amendment regarding cruel and unusual punishment, but that actually flows through the 14th Amendment Due Process Clause, so I'm not going to put that amendment front and center today because he's not a convicted offender. But if you look at some of the case law that pertains to these detention circumstances, the Eighth Amendment is definitely part of that narrative. But the Eighth Amendment is connected with the Due Process Clause. So really it all is covered by the umbrella of the 14th Amendment. So that's the basic law that we're going to address. There's also going to be some discussion today about a couple of different statutes. The first one being Indiana Code 34-46-3-1. And that is the statute that basically articulates the doctor-patient privilege, as well as other privileges that exist in the state of Indiana. The second statute, which is kind of married to this privilege statute, is 25-33-1-17. And those are the exceptions to the privilege statute. And those two statutes are not overly complicated. Basically, the first one says that the doctor-patient privilege exists and that any communications between the two parties are confidential. The second one says, oh, there's an exception to that rule, and that exception is that if there are statements made regarding a homicide or a homicide case, that those statements are not privileged. So we're going to talk about those two things more at the end of the presentation, and I think that kind of covers the basic law. The other thing I would articulate to the court is that in terms of the statements themselves, I like to think of them in basically 5 different buckets, if you will. I tend to try to compartmentalize things in my mind, and using buckets is a way for me to do that. The first bucket would be statements that were made to family members. The second bucket would be statements that were made, they believe, to other inmates. They're going to be referenced as inmate companions in this case. Basically, individuals that were assigned by the prison to sit at his doorstep and theoretically observe him. The third bucket would be statements made to guards that were assigned to his doorstep, so to speak. The fourth bucket would be statements made to the warden and to the chaplain in written form. And then the fifth would be the statements made to the psychologist, Dr. Walla, who will testify here today. So that's kind of my way of breaking this down, trying to make it consumable to the court. And I think that's how an appropriate roadmap I'm going to follow. Thank you.
Miss Diener.
Yes, Judge. May it please the court. The state has filed a motion to dismiss the request for suppression, and that would be where we would begin. I would agree with Mr. Rosie on the summary of the constitutional amendments, or the one that pertained to their request, and also the doctor-patient privilege and the exceptions that flow from there. We specifically filed that motion with regard to a psychologist, so that is one we're prepared to address today. I would agree with Mr. Rosie that there are categories of statements, and I would mirror his list, except to say that there's another category that contains multiple people within those buckets. So we do have calls to family, we do have statements to inmates that were assigned as companions at his door, or we do have statements to guards that were assigned as companions to his door, the warden, Dr. Walla. We do not have access to chaplain. None of those have been provided to us. So to the extent there are any to the chaplain, I don't know if that was an oversight because we were asking for mental health and medical, and that's somehow in another category. So the state doesn't have chaplain records. Dr. Walla, but then there's also video movement of Mr. Allen during which times he's making statements, and that may include nursing staff, the physician, Dr. Martin. It may include Dr. Walla. It may include the warden, but those statements might fall in another category. I would put them in another category, so we may address some of them in that context.
Well, why have the chaplain statements not been provided?
May I?
Yes.
Judge, I appreciate her bringing that up. Actually, I'm not able to locate that. There was a reference, I think, in the deposition, maybe with Warden Gallipo, or maybe it was in one of the other thousands of documents that I saw, that there may have been some type of letter written to the chaplain that may have been incriminating, and I was not able to locate it, but so I'm glad she brought that up because I don't really have it. I just know that there's some reference to it somewhere in the record that it might exist. So that's my response. I do have a couple things too,
Go ahead.
just to follow up on Ms. Diener's statements. This is kind of my view on how this might work, subject to the court's input. What I did today, and I actually have talked to Ms. Diener before today, I think what you're going to get are exhibits from us that just basically have, at least from me, what I believe to be the statements that are at issue that we have on paper. And I'm going to hand those to you with a thumb drive, and you'll be able to, sort through those. I think the idea, because of the volume of evidence, so what we're talking about here is a video camera, for example, that she mentioned that runs 24 hours a day, pointed on Rick Allen for the past 18 months. So just naturally, the volume of that is almost unmanageable in terms of picking out each and every little, segment of that could be incriminating. The second, and this is also in the video bucket, would be there's evidence you will hear that they also used a handheld camcorder that was focused on him whenever he would be moved outside of his cell. So anytime he was moved from cell door to any other place in the facility and back, I think even for showers and medical appointments, there would be literally like an old fashioned, camcorder. And so there's footage from that. And naturally, there's just hours and hours of that stuff. The third bucket that we talked about would be, and now we're kind of going back to the beginning, would be the family members And that would be in the form of audio and transcribed statements from that audio. And then the statements to the inmate companions would be in the form of log sheets. There's a different name for those sheets. I'm just going to refer to them as log sheets. So those are mostly written. And then the same with regards to guards. And then the warden is just a letter. So my point in telling you all this is that because of the volume of all this, it's difficult to be confident that I've got everything marshaled in one place and packaged for you to say, okay, these are the only statements that matter. So my view of this would be is that if the court either grants the defendant's request or either in whole or in part or some kind of limitations on this, that we would probably come back and have kind of a second hearing, if you will, where we're filtering through some of this. It's not just as simple as saying, he said on April 1st that I killed those two girls. Because what happens is that statement is made, and then 6 months later, there are statements to the effect of, well, they say I confessed. And so it's, I guess, for lack of a better phrase, it's kind of fruit of the poisonous tree type stuff. I don't want to get too technical, but that's the challenge with all this. And I'm trying to explain to the court my view of how we could work through that if there's some limiting instruction given by the court in whole or in part.
Anything else, Miss Diener?
No.
All right. You may call your first witness.
All right, Angela changed to Lala.
But I don't think we're done yet. Not according to you. Rosie keeps arguing.
Oh, yeah. Judge, I'd move for a separation order. May I just identify the witnesses and then you can admonish them?
Yes.
Are they all in here?
And before he steps out, Your Honor, I wanted to make a legal argument on dismissal of their motion for failure to be specific enough for the state to respond, if I may.
Yes.
We did file a motion to dismiss the suppression on May 17th, and the reason for such request was that, in our response to the motion, we laid out some case law that I would ask the court to consider as a result of today's hearing if witness testimony is taken with regards to whether the defense is even stating a claim that can be granted by this court. The motion itself starts out telling the state that they want to suppress all statements to state actors, so in interpreting that into plain language, that would not include statements to his wife or his mother because they're clearly not state actors. Then we could have a debate about whether the guards or the nursing staff or the doctor or the psychologist who are there to do their job are acting on behalf of the state. But then the motion concludes by saying all statements should be suppressed, which to me includes statements to his mother and his wife. So it starts out with a lack of clarity. The defense even goes on to state their issue is whether the state violated Allen's constitutional rights by detaining him in solitary confinement while awaiting trial. All of his statements are involuntary and should be suppressed. In preparing for this hearing and in looking at all of the case law they cite and all the case law that I asked the court to consider in response, and now ask the court to consider this motion to dismiss, basically asking for clarification, is that all of the cases talk about a clearly identified statement. In fact, the statement is contained within the case discussing it and the analysis of how that statement was evaluated by the court with regard to admissibility. And then there's clearly circumstances of custody. And we can see he is in custody. There's no question about that. But is he in custody for the purpose of an interrogation? That's the question. You can't take the words out of context. And so the case law talks about custodial interrogation by law enforcement or someone acting on behalf of law enforcement. And so when you say, we want to exclude everything that is said to a state actor, someone might say, well, a person employed by DOC or by a contractor who provides a personnel to the DOC, clearly they work for the state, they're getting paid by them, but that doesn't mean that they're acting on behalf of the state in the context of custodial interrogation. And that's what's missing from this equation. And so without them making an allegation that the state, through law enforcement or someone on behalf of law enforcement, has acted to influence or coerce the defendant's situation in order to elicit statements that are incriminating, I believe that their motion fails before we even get to the first witness. Interrogation is defined in Curry v. State, which I cite in the response, found at 643 NE whatever, indicates that interrogation can only extend to works or actions on the part of police that they should have known were likely to elicit an incriminating response during custody questioning. And so, irregardless of the headnotes that you grab from a particular case or whether they are contained in the analysis of the court, they always come back to, was this person in custody being questioned by law enforcement to obtain incriminating statements or someone on behalf of law enforcement? In this particular situation, Judge, The state's position is that the motion fails because they're not stating a basis that's found in current law. Their motion and their memorandum claims that they're not saying the incriminating statements or all statements are the result of interrogation. They are asking this court to suppress all statements for a novel basis. They say that they want the court to make new law here by saying coercion illegally directed to Richard Allen, resulting in involuntary statements that he made to state actors, not that the coercion came from state actors or that the statement was the result of interrogation. But he also made incriminating statements to his wife and mother, and there would be no state actor in those. So the defense memorandum says the methodology used by the justice system is one of first impression. Again, this is not based on an existing case law or statutes. They're asking the court to reach beyond and take the standard applied for the admissibility of a statement in custodial interrogation, and then the analysis of whether that statement is voluntary. Is it a voluntary waiver of Miranda? Is it a voluntary waiver of the right to counsel? Was it made knowingly, intentionally, and with free will? But they're jumping to the voluntariness without meeting the threshold. So, in an effort to address their representations to the court at length about all of the conditions that he's under and how they're so unique and so coercive that this court should step outside the law, one of the main things they say is, well, Warden Gallipoux at Westville was deposed, and he indicated that he's aware of no pretrial detainee in DOC other than the ones that he's dealt with, being Richard Allen, and one 5 years prior. However, that witness is not the appropriate source for that information. Mr. Allen is not unique. He is here in this current situation under this court's order based on the safekeeping statute that allows this court to make a determination that his safety is at risk, not just as a threat to others, but to protect him, he himself. And so in an effort to make this clear for the court, I have an affidavit of Dawn Stevens, who's the Indiana Department of Corrections Operational Support Services, and I provided one to Mr. Rosie, and she is essentially, and I've marked it States Exhibit 7, and I'd like to provide it to the court, which lays out the familiarity of this particular employee with DOC, with safekeepers in the statute under which they're directed to DOC, and the number of people in DOC as safekeepers, which are all pretrial detainees, and gave a 5-year history. So obviously 2024 is still ongoing, but for the year that Mr. Allen was admitted to DOC in 2022, there were 36 pretrial detainees in safekeeping in DOC and 8 that were referred to them that were denied. So I would submit States Exhibit 7 for the court's consideration.
No objection.
All right, so without objection, 7 is admitted.
So, Judge, to sum up the state's position, we believe that it is the defendant's obligation under the Criminal Rule of Procedure 27B to clearly state items to be suppressed that actually have a basis in law for a suppression. We feel that their request, as it's stated in this motion, is asking the court to create new law outside of what exists and that a legal basis for that does not exist. They say his pretrial detention runs afoul to his constitutional rights. Therefore, any and all statements should be suppressed. The defendant is charged with 2 counts. Well, the murder of 2 people, he has 4 counts. There is no statutory right to bail. People who are charged with murder are generally found in pretrial detention. It would be very unique for someone not to be. And if the DOC is following their standards and following this court's order and following the procedures for where he's placed, then his placement is not illegal, nor is the circumstances of his detention. So, the law does not provide a basis for suppression due to environmental factors without a person identified that would render all statements involuntary. I would submit the defense is fully aware that his statements were unsolicited in the presence of suicide companions, staff, medical personnel, mental health personnel, the warden, the lead psychologist, Dr. Walla, and to his mother and wife, and custodial interrogation by any legal standard is not taking place. For that reason, we ask the court to dismiss their motion for noncompliance under Rule 27B and the existing law that we have to work with today.
Mr. Rosie.
Thank you, Judge. So let's talk about Rule 2.7, the trial rule that regulates the filing of motions and the parameters for how that occurs. If you look at 2.7, first of all, I guess I should point out the obvious that we are in a notice of pleading state. The rule does further define that general concept that all lawyers are familiar with. And in this particular rule, the language that's pertinent is the following. It says, all written motions must include specific contentions supported by cogent reasoning and pertinent legal authority. So there's 3 prongs to that: specific contentions, cogent legal reason, and pertinent legal authorities. And I would suggest to the court that the first part of that, the contentions, all you got to do is just Google the synonyms for that word. And what you're going to find is that contentions means a dispute or an argument. So you have to raise a dispute or an argument in your pleading. It's as simple as that, which also is consistent with the notice of pleading concept. Pertinent legal authorities, specific contentions. The second one, the cogent reasoning, well, that's the argument section, which is contained in the memorandum, which is required to be offered up in some form with the motion itself, and we did that. The memorandum has plenty of detail and citations to all of the authority, a nice roadmap for you to work through each of those statements and confirm that those facts that are in the memorandum are accurate. That's the cogent reasoning portion of the rule. And then the pertinent legal authorities, of course, there are authorities cited in the memorandum, which I think we gave you. Well, I haven't given you a table of those authorities, but they're cited in there. And so you can shepherdize those citations and work through that in any manner you see fit. So I think the rule itself and the language of the rule is drafted, in a kind of parallel with the idea that we're a notice of pleading state. And I think for those reasons, the motion meets the minimum requirements. The other thing I would say is the motion itself does reference these buckets of statements, save the video statements that have been mentioned by Ms. Diener earlier. And I do agree that those would also fall within the umbrella of statements, but it does mention each of those, the statements to the inmates, the statements to the family, the statements to the warden, and so on and so forth. So there is some more detail in the motion. The body of the motion itself, the very first paragraph, references any and all oral and written communications, confessions, statements, or admissions alleged to have been made during his pretrial detention. That covers, the gamut of statements that we will be addressing today. The state claims that the state wants to drag the court into this idea or this argument that, well, this is about the custodial interrogation, and I do agree with that in part. There's obviously no argument that he's not in custody. He's obviously in custody, as the other way of putting that. So that's really not on the agenda for today. Whether or not these are interrogations is an issue of fact to be determined by the court. And I would suggest that that is probably where the battle is. Where are the parameters, or what are the parameters, as to whether or not any particular conduct by the state rises to the level of an interrogation? And so that's going to be one of the things the court's going to have to reconcile moving forward. Your Honor, to the law, here's the facts. Now look at the law. That only pertains to the Fifth Amendment. This motion also references the Sixth Amendment, on which Mr. Allen's right to counsel at all critical stages of the proceeding. And to the extent that he is detained by the state, and to the extent that they are assigning state actors to his surveil or his observation, and those people are engaging him, the defense argues that those are critical stages, and so the Sixth Amendment applies to, which is not an argument about custodial interrogation. In addition, the 14th Amendment, also referenced in the motion, the due process clause, kind of the umbrella again here, applies as well and the standard has nothing to do with a custodial interrogation. So there are other bases upon which the motion is brought to the court today. The second one, please. 1 second, please. From a practical standpoint, I think the argument in the motion to dismiss is, well, we don't know what statements they're talking about. If you just read the motion, that's really what it says. And the practical side of this is that's why we have hearings, is so we can educate the court about the details involved in these circumstances. And again, I would report to the court that there have been 2 depositions taken in this case that I think are pertinent. One of Warden Gallipo, who you're going to hear soon, and a second by Dr. Walla, who you're going to hear from today. And throughout the course of those depositions, the parties, both the state and the defense, vetted, if you will, or I should say reviewed the documents in other forms, whether it be video or audio, that exist where these statements were made. And in fact, I believe, I'll ask her when she's on the stand today, I believe I gave all of those documents to Dr. Walla before I deposed her. I packaged them up and sent them to her and said, you need to have these ready to go because we're going to talk about them. And I packaged those up for the court today, again in the exhibit. So I think there'll be some definition, if you will, of those statements that would be offered up at a hearing. This is what hearings are for. And beyond that, I have one other thought, and the other thought is it's kind of obvious, and that is that a great deal of this information was given to us by the state, So, to sit and act like I don't know what statements they're talking about. Yeah, I mean, technically, maybe when it comes down to every little statement, because of the volume of them, it's hard to track. But this is information, by and large, save Dr. Walla's involvement. But the rest of the information is information given from them. It's the typical, here's your weekly discovery dump, here's more video, here's more audio, here are transcripts of statements of officers that the law enforcement team has gone up and interviewed. And they give those to us, so we learn about them later in time, but they're things that we've gotten from them. So it's not like there's some, that we're playing some reindeer games here and, not offering these things up. We're getting them from them and trying to sort through all those to figure out, what's damaging and what's not. And so that's the context of those. And I'll finish with this. The state argues that the basis upon which we are requesting suppression is novel. That was the word she used, novel. And I'd suggest to you there's nothing novel about the Fifth Amendment of the United States Constitution, the Sixth Amendment of the United States Constitution, the 14th Amendment of the United States Constitution, or any of the provisions in the Indiana Constitution that deal with those amendments. And I'd ask the court to take that into consideration moving forward.
Anything else, Miss Diener?
No.
So here's my concern. How did the statements that Mr. Allen made to his wife and mother come under the umbrella of state actors as argued by the state?
Thank you, Judge. Well, first of all, again, that's a due process issue. It's a 14th Amendment issue. And that is to say that because of the way he has been treated pending trial with pretrial detention that occurred by the way of the safekeeping order that was entered by the former judge in this court without a hearing, without notice, an opportunity to be heard by him or his lawyers, put him in that hole up in Westville where he was detained for 7 months before any of these things occurred. And so it's the action by the state, i.e., the signature on that order, and then their ultimate detention of him in the circumstances and the manner that they saw fit, not that he agreed to, or not that you agreed to for that matter, that drive that argument. So they're due process arguments, and that is, that's how out of those circumstances came these statements to his family members, and that's why we believe they're suppressed.
But doesn't your argument go to the weight that the jury could give those statements rather than its like their admissibility?
I appreciate that, and I've thought about that a lot lately. And as the court may be aware, there is a statute. It's actually case law, I think, that requires at a trial in this case that a jury would find beyond a reasonable doubt that those statements were voluntary. So if we tee this up, so to speak, in October, and those statements are part of the evidence, in other words, if we fail today, then there is a standard that exists. But our argument is that that's putting the cart before the horse. You are the finder of fact today as it relates to reconciling facts in terms of testimony. But at the end of the day, we're asking you to make a legal decision or render a legal opinion on the righteousness, if you will, kind of a broad word term for how these things were acquired. But when we get to the jury, the idea that they would be dealing with that standard beyond a reasonable doubt and the voluntariness of those is a factual reconciliation by the jury. So I see it two different ways.
Miss Diener?
Judge, with regard to this court's function of being a fact finder with regard to admissibility, it still takes you back to the case law about due process, the Fifth Amendment, the Sixth Amendment, Article 1 of the Indiana Constitution, and the question of voluntariness comes after an analysis about whether his Miranda rights were given and waived appropriately, which would cover both the Fifth and Sixth Amendment. So when you have him making statements to his wife and mother in a phone call that he initiates that has an advisement that this conversation is subject to recording, they're jumping over the hurdle of custodial interrogation and asking this court to find environmental factors as the coercion that would normally be attributed to a person in every case. I cannot find a single case that says environmental factors can be the coercion that results in a defendant's statement being involuntary because it violated his Fifth and Sixth Amendment right. I can't prove a negative, it's just not there. And when they say that we're supposed to show that the voluntariness of the statement is beyond a reasonable doubt without the jury being able to hear all of the statements that we choose to present in their context, which they can then respond to and provide additional context to, we would be asking them to operate in a vacuum. So again, if there's a particular statement that they can point to that says this particular suicide companion was harassing Mr. Allen until he gave him a statement, then let's talk about that. We wouldn't want that to be happening. But we're talking about 61 statements over the course of 2 months that are all made to all of these buckets. And they are given over a period of time to different individuals. If you can point to a person that interrogated a statement out of him, we'd be happy to respond in kind. But they're skipping over the threshold that this court would be most involved in. Because even if you find it's voluntary, we argue that to the jury. So today, I believe the question is, did we violate his rights by subjecting him to custodial interrogation? Because even the cases that talked about coercion outside of an officer acting blatantly, the case law says it's only what an officer could anticipate or be, should have known would have coerced a defendant to make a statement. We have cases about mental health, but again, the court says mental health alone is not enough to make a statement involuntary. We have intoxication, whether that's a person voluntarily being intoxicated or someone who's ordered to be medicated or is under the influence of a drug for whatever reason. Again, by itself, not dispositive of a voluntary statement. So that's why the state feels so strongly about the court recognizing that they are skipping over custodial interrogation, and there's not a case out there that says that that's not important. And even in cases where they say that the officer was not overly coercive, there is a case where they hold him responsible for questioning a person who's in a mental health ward and is under the influence of psychotropic medication. That doesn't fit this case. There's no police interrogation.
Anything else, Mr. Rosie?
Judge, I feel like we're kind of getting down the road to, okay, now we're making final arguments after we've heard the evidence. The idea that there is case law that either does or doesn't support this concept of environmental factors being a party to or applied to his circumstances is more of an argument that the court really should tackle. And I would suggest to you, look, Nistiner says that there's no cases out there that support this. Well, there are cases that talk about environmental factors. The majority of those cases pertain to circumstances where you've got police officers bringing in accused parties or suspects or persons of interest and putting pressure on them in different circumstances, whether it be locking them in a room at the police station with no light and for hours and hours and depriving them of food and all those other things that are environmental factors. And so there are cases out there that do exist. How many cases there are with regard to 51-year-old men who are pretrial detainees who have no criminal history, who have been incarcerated without a due process hearing? That's novel. That's when you use the word novel. There are none that I can find. I do acknowledge that. I'm not saying I might not come up with one between now and, the time that we're done submitting evidence in this case and arguments, but I agree it's an unusual situation. Thank you.
Okay, well, thank you for the great legal argument. I mean, I had concerns when I read this is the motion in limine that you submitted. I mean, it's 3 inches thick and it has an awful lot of information. The state then filed its response requesting the dismissal, and the state's arguments are well founded. At this point, I'm going to take the state's motion to dismiss under advisement pending the resolution of the hearing. But I am concerned about there's no police interrogation. I am concerned that there's family members that are clearly not state actors, but we're all here, and I will take the state's motion under advisement, and you may proceed.
Very good. Thank you. Now I'm back to where I started when I was trying to leave. One second, Judge, if I could grab the witness.
Sure, go ahead. Witness anytime, witness anytime.
1 second, Your Honor. I'd call Dr. Monica Walla.
We'll give the witness a couple minutes to get into the courtroom.
Well, you know she had to be escorted in. Okay. Uh, Go ahead and state your name.
Sorry, I'm switching transcripts. This is just 2 seconds.
It's okay. Volume 5, page 71.
Okay.
Okay, now go ahead and state your name.
Monica Walla.
And
You can go ahead and just like sit back normally in your chair. That will pick you up just fine as long as you speak up nice and loud.
Okay.
you're a psychologist, right?
Yes.
So calling you Dr. Walla is okay?
Yes.
All right, very good. Dr. Walla, spell your last name for the court reporter
WALA.
and tell the judge where you work
Westville Correctional Facility.
and what do you do there.
I'm the lead psychologist.
And were you specifically assigned by the administration there to basically treat Rick Allen?
Yes.
Okay, Richard Allen, sorry. Yes or no?
Yes.
Okay. And I may remind you to say yes or no a few times. Don't get upset with me. We're just trying to pick up a recording, okay? Yes?
Yes.
All right. And tell the judge how long you've worked as a psychologist at the prison.
Since 2017.
And did you work as an acting psychiatrist or a licensed psychiatrist anywhere before that?
No.
Did you say no?
I said no. Yep.
Okay, I keep cutting out. Okay, basically the prison life has kind of been your life in the medical/psychiatric business, right?
Yes.
And in the context of you being his doctor, I guess, if you will, did that include communicating with him about private matters?
Yes.
Is that a part of your relationship with the patient?
Yes.
Was it a part of your relationship with Mr. Allen?
Yes.
Personal matters also,
Yes.
and just general healthcare matters
Yes.
involving psychiatric issues as well?
Yes.
And did you have contact with him on a weekly basis, or how would you describe that?
It varied over time. Initially, it was every day for about a month, and then it was maybe weekly for 4 months, and then it went back to daily.
And just to kind of get cut to the chase, so early on, you're visiting him weekly, and that was during a time period where there really weren't any concerns about his general mental health. Is that fair?
Yes.
And then at one point, you said that there was about 4 months where it was daily.
The opposite. So initially, when he first arrived to the facility,
Oh,
he was seen every day for about a month. He was on suicide watch at that time.
I'm sorry.
And then when we took him off suicide watch in December of 2022, he was seen once a week up until April of 23.
And then it was more intense.
Yes.
Yes or no?
Yes.
Okay. And then did it become daily or how intense was it?
Daily.
And that was for about 4 months.
I believe he ended up having daily contact with me or someone else until he left our facility.
So from roughly April of 2022 to December of 2023.
Yes.
All right. And now, when you say with someone else, do you identify or are there designated mental health providers other than doctors in the prison?
Yes.
Okay. And are those people basically just common lay people without a psychiatric education,
No.
educational backgrounds?
They would be master's level therapists.
Okay. And how many of those worked for you, were underneath your
4.
authority at the time that Rick was there?
4.
And then do you have even a lower level of mental health provider? And I've seen all these acronyms in the guides.
Behavioral health specialists.
BHS, right?
Yes.
Now, do they have any what I call formal psychiatric trainings or?
Bachelor's in psychology.
Okay, and so when you say that people are having contact with him in a general sense, it could be any one of these three types of individuals, right?
For the most part, yeah.
Do the majority of these contacts occur with Mr. Allen while he's inside of his cell?
So I would say a good portion of them would. So what we have, what we call rounds, is when one of the providers walks the ranges and speaks to people at their cell fronts. So at that point, that individual isn't pulled out of their cell. For Mr. Allen, I believe that was at least twice a week, and then we would offer at least once a week to come out of cell.
Okay, and so forgive me, but my view of this is one of these BHSs or maybe one of the other staff members walks down the hall and knocks on the cell door and says, "How are you feeling? Can I get anything for you?" Is that kind of the typical round?
For the most part,
Okay.
we want to look into, where their head's at, any thoughts of self-harm, suicide.
Okay. You're talking to somebody through a metal door, right?
Yeah.
And the little slit that they get fed through, right?
And through the crack of the door.
Okay. Do you open the cuff port every time you talk to?
No, you can't open it.
So you don't even get to do that.
Mm-mm.
Shaking your head no.
No.
So the mental health intervention, I shouldn't say intervention, the mental health contact at the cell basically is you talking through a crack in the door.
Yes.
And when you met with Rick the first time, do you remember that meeting?
Yes.
The first time you met with him?
Mm-hmm. Yes.
Okay. And was that contact in the cell or was it outside of the cell?
It was in a different area, so it was a barred cell and I was outside.
Okay.
And he was inside, so I got to see him. There's not so much of a barrier.
So it was not in the cell in A107.
No.
Oh, I know I was struggling earlier. Now I know what I was going to ask you. When these contacts occur at the cell door through the crack, those are part of mental health providers doing rounds throughout the rest of the facility, right?
Yes.
So you might go check on several dozen inmates in a day and do a round.
Yes.
I mean, there's 255 roughly, apparently, in that unit. Do you acknowledge that generally?
If you did the math, 14 times 4 in one pod.
And there's 4 pods.
4 pods.
Okay, so when you do those rounds, you're talking to dozens of people in a day, right?
Right.
You can't sit there for hours or even lengthy periods of time and communicate with inmates, can you?
No.
Back to the first contact. So you recall that being in the WCU unit,
Yes.
and you recall removing Mr. Allen from his cell too.
He was there when I arrived. That's where he was placed.
Okay, so he was placed in a holding area where you meet with patients, or I should say, yeah, patients on a routine basis.
They let me know he was there.
Okay, and we talked about that particular setting, right?
I think so.
When I took your depo.
Mm-hmm.
Yes
Yeah.
or no? Okay. We'll get to that in a minute. When you first met with him, did you have him sign any documentation?
I may not have. He arrived to us on suicide watch from RDC, and he would have signed the documentation there. And so if he was already in the suicide watch condition, he wouldn't have had a pen or anything to sign with.
So the answer is you did not, right?
No.
Because he couldn't even have a pen
Right.
when he hit the doorstep at Westville, correct?
Correct.
So did you review the documents that he signed from RDC, Reception Diagnostic Center, right?
Briefly,
Okay, what would those documents entail?
just a quick intake, background information.
My recollection is basically these are the basic rules and you have him check some boxes and then you sign. He signs his name, right?
If you're talking about the limits of confidentiality form, then yes.
Okay, well, tell the judge what you did with him in terms of his discussing with him his confidentiality issues.
I don't know if I really addressed confidentiality that first day.
Okay.
When they're on suicide watch, it's more of an emergent situation, so sometimes those documents are bypassed until the individual is off of suicide watch.
Okay, when were they done in this case?
I believe we kept Mr. Allen on for about a month at that time.
Well, when were the When were these, I'm going to call them consents or whatever, signed by Mr. Allen in this case?
Ooh, I couldn't tell you. I mean, the ones that he signed at RDC still carry over and they are relevant for our facility as well.
Okay, what do those waivers say about confidentiality?
They let the individual know that there was 8 things, and all those 8 things pertain to harm of self, harm of others, harm towards anything in the facility. And if they refer to any of those things, that we would have to tell someone.
Okay, basically that if they're putting somebody else in danger, that you have an obligation to report him.
Yes.
Otherwise, the report suggests that your communications with him are confidential, right?
Yes.
Strictly?
Yes.
Okay. Nothing else?
There may be a blurb about group therapy if one chooses to engage in that.
Okay.
It wasn't an option for Mr. Allen.
No chance at group therapy, right?
No.
All right. Let's talk about the circumstances in his cell. You're generally familiar with those because you visit it, right?
Yes.
Visited it. I'm sorry. Shaking your head, yes.
Yes.
Earlier, I asked Warden Gallipo. I believe he suggested there was about an 8 by 12 cell. Does that sound correct?
Sounds correct.
He spends 7 days a week in the cell, right?
Yes.
And from what I've heard different stories on this, but how many hours of rec a week do you think he got in rec?
Rec is supposed to be 3 times a week.
Okay, and that's if you're not on suicide watch, right?
We did modify his plan while he was on suicide watch to include rec. Whether or not that was carried out, that's on the custody staff there. But I believe on our orders, we would have put allow rec.
Okay, but there were times when he was on suicide watch when he didn't get rec, right?
In situations, if he didn't have a smock, it would be inappropriate to just come out wearing, a smock and have everybody observe you. So,
Part of being on suicide watch is wearing a smock.
mm-hmm.
I-
Yeah,
Is that accurate?
correct.
And is it accurate to say that that smock is basically a gown that's thrown over the body of the inmate to simply just cover kind of the bare essentials?
Yeah,
I referred to it as a caveman garment, didn't I?
I think you did.
And you didn't disagree with me, did you?
No,
And one of the problems with wearing that is that your privates can be exposed fairly easily, right?
can be.
And going to rec and having activities is one way that that could happen.
Yes.
So it's a deterrent for recreation.
Yes.
Forgive me for a second. I'm just going to get my calculator out here. How long is a rec session?
I don't know.
I heard an hour. Does that sound right or not?
I don't know.
Do you think it's longer than that?
I believe guys can get stuck in rec if staff don't take them out in time.
Okay, so they can go in there and they could kind of not get out because of other administrative issues.
Yes.
If in fact it was an hour, basically, the inmate would have 3 to 4 hours out a week, right?
Yes.
I did the math. It's about around 2% of the time, the total time in a week that somebody would be afforded rec. Do you have any reason to dispute that math?
Not necessarily.
Judge, it's Miss Diener. May I object? And I really don't want to in the context of this hearing, but we're talking about rec with his psychologist, and I'm just not sure it's relevant to what she can provide to the subject matter we're here for. We had the warden here, and relevancy.
Judge,
I asked that we limit it.
sorry?
Relevancy?
Judge, she's intimately familiar with his detention circumstances. She's already described that she visited his cell 2 days a week. I know from deposing her that she spent time with him there on the unit, so I think she's got firsthand knowledge. So I do think it's.
But she just said, I don't know how long rec is, and I don't
I understand, but
know about rec.
I'm sorry.
Move on. I'll sustain the objection.
I'm going to move on from the rec thing. I thought she was talking about in general.
That's what she said. I don't know how long rec is.
Okay, thank you. Did you observe any of the video from Mr. Allen's cell at any time while he was housed there?
Miss Walla?
Miss. You're muted. I don't know if you know.
Oh, be right back. Hold on.
Oh.
There was a BRB I missed.
And I'm sorry, obviously, while we're waiting for Dr. Walla, I'm going to say something, but I think that there's probably certain things that she would not be aware of. Knowing how much control she had over him in terms of his ability to leave the cell, um, his ability to shower, when he received medications, when the nursing staff would come through, I find it incredibly difficult to believe that throughout her controlling all those other inmates too, that she has no idea how long rec usually is, considering she is who takes rec time from them and gives it back.
It's like how unprofessional to just be like talking to these inmates just through their door.
A
Like just
crack in the
how
door.
how is that even like where's the privacy in that?
Privacy so other people can't hear you, but also, like, what is the purpose of meeting with a psychologist to deal with things like that when they can't even really see you to observe you, number one, and number two, you're, like you said, with privacy, you're talking out in the open, and you have suicide companions sitting right there listening.
The guys, remember, like he's not convicted of anything at that point.
Right.
And this is how he's treated. He can't even talk to his psychologist. You don't see my air quotes. His psychologist face to face the majority of the time. He has to talk to her through a crack in the fucking cell door.
She can't even open the slot for the trays, like to look through the little slot. You know what I mean?
And he has to walk around wearing a suicide vest that his junk can just be seen by anybody. Like how fucking degrading. And then you're going to tell me at the beginning of this that there was no environmental factors to
Yeah.
his
Well,
that,
and you're basically encouraging him to, even if he was allowed rec time, you're basically discouraging him from following through with it because your junk can come out, number one. And number two, love how she admits that sometimes they put people outside for rec and then like forget or get busy and then leave them there for God knows how long.
yeah. So like
Which I'm sure if you've been stuck in, I'm sure if you've been stuck in solitary, you're probably grateful to be out, I guess. But really, you're just so you're restricting some people and then you're forgetting other people.
just sort of fucking. It's probably the people who don't want to be outside that get forgotten.
Probably.
Wallet is back in the courtroom. So
Hi.
Okay. So let me see where I think I said. Oh. Um.
did you observe any?
Yeah. So we're on line 20.
Mhm.
Did you observe any of the video from Mr. Allen's cell at any time while he was housed there?
I
Okay.
probably did.
Okay. I saw in some of the video that he did a lot of pacing back and forth, back and forth. Is that something you're familiar with?
Yeah.
That's one of the ways that inmates can pass time.
Yes.
And it's a very, do you agree that it's a very monotonous activity?
Yes.
And do you agree that that's one of the forms of, I was going to say recreation, I guess, in some ways, while they're in their cell, right?
Yeah, it could be.
Okay. How many steps would you think it is from one end of a cell to the other?
15.
Okay, so back and forth 15 steps, right?
15 one way, 15 back.
Okay.
That's just a guess.
And you're aware that those cells have lighting?
Yes.
And did you tell me that you believe that those lights were on all night long in some form?
I do recall Mr. Allen telling me about a light that he didn't want to turn off because he was worried he'd get in trouble. I don't know if that's different from a light that's normally on, so it's not pitch black, not.
Now, when they're on suicide watch, strike that. I mean, I didn't mean to interrupt you. Go ahead and finish.
No, you go on.
When they're on suicide watch, they have lights in their cell all the time, right?
That's probably ideal in that situation.
Do you recall telling me that you didn't believe that he had any ability to control the lights?
I don't think he did.
Okay, that sounds accurate, right?
Yes.
Somebody else deals with all that.
Yes.
And you told me that there's no privacy at all in that cell, is there?
No.
Okay, there was a window in his cell. Do you recall that? Do you recall that being a problem when he got there in terms of his ability to see outside?
Yes.
Okay, what was the problem?
It was scratched up, so he couldn't see out of it.
And did you look at the window, confirm that he was telling you the truth?
Yes.
And do you think it needed replaced?
Yes.
And the prison accommodated that, right?
Yes.
Okay, now his view outside of that cell is basically a barbed wire fence, isn't it?
I think so.
I mean, there's a fence around the WCU, right?
Mm-hmm.
Yes or no?
Yes.
It's got its own special fence, doesn't it?
Yes.
With barbed wire on top, right?
Yes.
And then beyond that is just a view of the rest of the prison, isn't it?
Yes.
So that's what he would have been looking at.
Yes.
Do you acknowledge that he was sleeping on a mattress that really was on the floor?
Yes.
And do you acknowledge that that's where he ate his dinners and lunches?
Yes.
On the floor, on the mattress.
Yes.
And do you acknowledge that there were times when he was even fighting with bugs while he was there?
This is what he told me.
Okay, and that's something that you're familiar with at the prison, isn't it?
Yes.
That problem? Yes or no?
Yes.
And in fact, you told me that there was even problems with, there was like mouse droppings.
Yes.
Well, those kinds of things can cause a man to go crazy, can't they?
Objection.
Crazy, I mean,
What'd you say?
I'm saying, I mean, it depends on what you mean by crazy.
Oh,
But yes, it can be distressing.
do you acknowledge that he was in the most isolated of circumstances at that prison?
There are 3 other cells that are very similar.
Okay, so of the 255 in the WCU, there's 4
Yes.
that are similar to that, right?
Yes.
No others that are that isolated and that secure, right?
There's one that is similar on the infirmary.
Okay, we'll talk about that in a minute. We talked about that in the depot, right? Shaking your head, yes?
Yes.
Do you acknowledge that one of the problems that existed while he was in that facility is that a lot of the other inmates were yelling at him routinely?
Yes.
Tell the judge what kind of things they would say to him.
Kill yourself.
Do you remember them calling him baby killer?
Sounds about right.
Okay, and that was something that persisted over time, wasn't it?
Yes.
It bothered you, didn't it?
Mm-hmm. Yes.
We talked about how noisy it is on those units, didn't we?
Yes.
Yes or no?
Yes.
And do you agree that it's extremely noisy on those units?
Yes.
And that noise adds additional stressors to the inmates?
Yes.
And it specifically did with Mr. Allen.
It
He told you that, didn't he?
He would tell me sometimes, yes.
And you believed him, didn't you?
Yes.
Did you evaluate, strike that, are you familiar generally with Rick's medical history when he entered the prison?
Depression.
No, go to 7.
Oh, sorry, cardiac issues. Sorry.
Okay, are you or were you familiar with Rick's psychiatric history when he entered the prison?
Depression.
Okay, so let me back up. I'm getting ahead of myself. With regard to the medical, you're aware that he had heart-related issues?
Yes.
And with regard to his psychiatric situation, do you acknowledge or was there an intake done of him at RDC?
Yes.
Okay, were you part of that intake?
No.
All right. And would that intake at RDC involve any formal testing of his psychiatric circumstances?
No.
If I described it as basically a sit-down interview with him, going through some questions, checking some boxes, is that what happened?
Yes.
That's what would normally happen, right?
Yes.
It's not a real clinical process, is it?
It's still a clinical process. It's just a structured interview.
15 to 20 minutes, maybe?
Yeah.
And do you acknowledge that his intake form mentioned that he had major depressive disorder?
I believe so.
And do you acknowledge that major depressive disorder can be defined as a serious mental illness?
Not for our standards.
Okay, what about the standards of the DSM-4, Axis 4?
I'd have to disagree.
Okay, we're going to get back to that in a minute.
Okay.
Serious mental illness, SMI, is a distinction or a phrase of art in your business, right?
Right.
Okay, and you acknowledge that Rick had reported to prison officials at his intake that he had a long history of suffering from depression.
Yes.
It went all the way back to his early adulthood,
Yes.
and that he had been suffering from depression for about 8 to 9 years prior to his admission at the prison,
Yes.
and that he was even hospitalized at one point in 2019 for more than a week to address those conditions.
That's what he told me.
And you didn't have any reason to disbelieve that, did you?
No.
And that he had been taking, do you acknowledge that he had been taking psychotropic medications back to age 25?
Yes.
Do you acknowledge that his file indicated that he had risk factors for suicidal ideations back in time before he was admitted?
I believe so.
Let's talk about that real quick. Well, actually, we'll get to that in a minute. Do you acknowledge that his record reflected that he had also had generalized anxiety disorder?
Yes.
And I think, do you acknowledge that you told me at one point that you actually thought he probably suffered from dependent personality disorder as well?
It's a possibility.
Okay.
I don't,
You saw a lot of those characteristics,
some of the traits.
which is that when you're separated from the people that you love, it can impact your mental health more than just the normal person, right?
For those individuals, yes.
Okay, and he was one of those people, wasn't he?
Possibly.
Okay, based on what you knew about his relationship with his wife,
Yes.
but that's a formal diagnosis in your industry, isn't it?
It is.
And I think he was labeled, if I recall, as a code D or something like that, is what I saw on the record,
Yes.
right? And you can jump in here, but am I correct in saying that you have 6 designations, A, B, C, D, E, and then there's this kind of F that's its own, right?
Yes.
But the A through E are the designations. Is it accurate to say those are the designations that define the significance of his current state of mental health,
Yes.
or the acuteness?
Yes.
Is that a better
Yes.
way of putting it? You're shaking your head, yes.
Yes.
And he was a D, right?
Correct.
So an A would be the least acute, I guess, if that's the right word or phrase, correct?
Yes.
And then a D would be Well, E would be the most acute, right?
Yes, someone we would have to transfer out of a traditional facility.
Okay, and then he was just right next door to that. He was a D.
Yes.
And if you were going to transport somebody out, would you transport them to a place like Newcastle, which is designed to treat mental illness?
Usually Newcastle. We have 3 different facilities we can choose.
Okay, I mean, Newcastle's kind of the sister ship. I don't know if that's the right phrase when it comes to mental health treatment in the DOC, right?
It's where we send the most.
Mothership's what I meant to say.
Okay.
Is that fair?
It's where we send the most acute patients.
Okay, so he was, from a mental health standpoint, he was fragile when he was admitted.
Yes.
And then on top of that, he was detained in this solitary situation, right?
Yes.
And then on top of that, he was being accused of killing 2 young girls, right?
Yes.
So to describe him as an eggshell inmate, somebody who was very thin in terms of his state of mental health, is accurate, isn't it?
Sure.
Let's talk about his offender status, his inmate status at the prison, okay?
Okay.
Are you aware of any documented records? Am I being redundant? Are you aware of any records that suggest that he was having suicidal ideations when he was admitted to the prison?
I want to say, if I'm remembering correctly, they documented that he was not actively suicidal, but that he's a high risk.
Okay, because of his circumstances, right?
Yes.
The fact that he was there on an accusation, a criminal accusation, right?
Yes.
But there was never any suggestion that he was doing anything to harm himself or others, right?
At the time, no.
Okay, but do you acknowledge that he was placed on suicide watch anyway?
Yes.
And because of that, again, his restrictions or his privileges are limited, right?
To an extent. We usually, again, like I said, we monitor them, and over time, once we observe and notice stability, then they can get things back.
And so he was on either constant supervision or close watch, I think, are the phrases you use.
Yes.
And that went on until at least until late December slash early January,
I think it was early December.
early December.
I think so, early to mid.
Okay, and at some point he was stepped down to 15-minute observations. Is that accurate?
So that would suggest that he stepped down to close,
Okay.
which would make sense, yes.
All right, but still on suicide watch.
Yes.
All right, he stayed in a suicide cell the whole time he was there, right?
Yes, but part of that was the intention. Administration was going to keep him in that cell anyway.
No matter what.
Yes.
His state of mental health didn't matter to administration, right? They were just going to keep him in there.
They were going to keep him there.
Yep, even if you told them different.
It was the safest cell they had.
Okay, so he stayed in the suicide cell under close supervision until roughly the start of April 2023. Is that accurate?
Stayed off of it until the beginning of April.
Well, but he was still in the suicide cell.
He was living there. Everything else was normal for him.
Okay, he was not on close observation.
No.
All right, but 1st of April, basically, roughly.
Right. I do believe he still had a companion, though,
Okay.
during those months. So January through beginning of April, he would have still had a companion watching him despite being off. And that's an administrative decision.
All right, so he had this companion assigned from January to April, even though he was not suicidal.
Yes.
And that decision was made by administration.
Yes.
And then he went back on suicide watch in April.
Yes.
Basically, the 1st of April 2023, roughly. I mean,
I think it's the 4th.
within a day or two, right?
Yeah.
And he stayed on that particular status until he left in December of 2024.
Yes.
And all the restrictions that come with that.
They fluctuated.
Well, did he ever get more than 4 or 5 hours of rec at any point in time?
I
per week?
It would have been offered to him.
More than that, I'm saying.
Whatever's the standard is what he would get.
Okay, so you thought it was 3.
I thought it was 3, maybe 4.
One of those restrictions on suicide watch is that you get a suicide blanket. Is that right?
Yes.
So for the first month or month and a half that he was there, did he get a suicide blanket?
Yes.
And is that a blanket that they take away in the morning and give it back to you at night?
Technically, they're supposed to. I don't know if they did.
Okay.
I don't know how consistent they were with doing that.
It's like a really hard blanket so that you can't like tie it and
You can't tear it up. I mean, they still do it, yeah.
okay, not a luxury item. Would you agree with that?
I agree.
You're aware of the Suicide Companion Program, is that correct?
Yes.
Let me take a drink of water, excuse me. And you've already mentioned that there was an inmate or there were inmates that were assigned to his cell by the administration, right?
Yes.
Did you order that to occur?
No.
Do you have the authority to do that?
When we send orders, someone else takes that on. So they say that we want a companion, they locate the companion, whose it's going to be, and assign them to their job.
Are you in charge of that program?
I'm not.
But do you have anything to do with the administration of the program?
I'm not. No.
Okay, so you can make a request and then you're at somebody else's mercy in terms of getting that.
Yes.
Is that accurate?
Yes.
And is it accurate to say that with regard to Rick's suicide companions, you had problems with them from the beginning?
Yeah.
They were talking to him, weren't they?
Yeah.
Were they asking him questions about his circumstances?
That was my understanding.
And do you acknowledge they could have been talking to others about his case?
Yes.
And do you acknowledge, is it accurate to say that they were talking to other people on the units about his case?
I believe so.
Is it accurate to say that some of these inmates were actually calling their family members and talking to their family members?
I believe there was at least one instance of that.
Is it accurate to say that you cannot trust those companions considering their backgrounds?
Yeah, it's fair to say.
And do you recall Rick actually reporting to you that he was frustrated with the companions?
I think so.
You told me that in the deposition, right?
Mm-hmm.
Yes or no?
Yes.
Do you acknowledge that the companions, by rule, are prohibited from communicating and engaging the inmates?
Correct.
So these would be violations of that policy.
Correct.
Do you agree that they would be clear violations of the policy?
Yes.
Did you do anything to report any of these violations when you heard about them from Mr. Allen?
I don't think I did. I do recall our very first meeting when Mr. Allen was telling me that they were asking him a bunch of questions, which is not, it does not violate the rules of the program. A lot of times we have little control over all of that because, oh, sorry, it does violate the rules of the program. A lot of times we have little control over all of that because there's not another person that's watching them
So
who can confirm that it's happening.
so is it accurate to say that you're trusting felons to watch the inmate, Mr. Allen, in this case?
That's the way the system works.
Not a very good system, right?
Could be better.
And is it accurate to say that those inmates were ultimately, I don't want to say fired, but they were let go of their duties for disclosing these confidences?
I believe when he went on suicide watch in April is when it switched over to officer watch.
Okay.
So
Are you aware that, is it accurate that those inmates were relieved of their duties? Is that fair?
I don't know to what extent, whether they were still allowed to continue elsewhere or with other individuals, but they were obviously not working with Mr. Allen anymore.
Would you have more knowledge about the inmate companion program than the warden?
It's a DOC program right now, and I think since Mr. Allen left, they made it a whole job. So now they're just hiring the incarcerated individuals into these positions. I know that they receive training every 6 months, and that's about it.
Are they paying them?
They are paying them.
Do you know if they were paying them when Rick Allen was there?
That was when it was the Plus program, which I believe you get paid when you're in programming, so they probably did get paid.
Okay, so these were jobs
Mm-hmm.
that these people had
Yes.
just within the walls of the prison.
Yes.
And this is kind of an outlier issue, but I asked you about outsiders having contact with Mr. Allen while he was in prison. Do you remember me generally asking you about that?
Can you be more specific?
Yes, I can. Thank you. I saw a record that in March of 2023, there was a forensic psychologist from the state police that wanted to talk with Rick Allen. Are you familiar with that record?
I do remember that instance, yes.
Okay, and were you involved generally with that instance, just the passage of information?
I don't remember the details. I remember someone did come around, and I believe it was shut down, so nothing happened.
Okay, do you remember me asking you about this?
Yes, and it was just so vague, but I don't think anything came of it.
Okay, there was a doctor referenced in the document by the name of R. Goldenberg. Do you recall that?
No.
Okay, do you remember the document being something that you created that referenced this circumstance?
I may have put it in my note if
Okay, well, do you remember asking Rick Allen for his consent
as to whether oh, okay.
as to whether or not this person could have contact with him or with you about him?
I think I did it. I don't know who directed me, but somebody said, go ask him if he wants this.
All right.
And we both agreed that it would not be a good idea.
Okay, so you do remember this.
As we talk about it, I do remember it.
Okay, so would you believe it would be appropriate for him to talk to somebody from the state police
No.
in that setting?
No.
But did you go to him and ask for his consent anyway?
I think he made the decision and I was just obviously in agreement.
No.
Oh, sorry.
10.
Oh, yes, I was supposed to get something signed from him saying yes or no.
Okay, so you did that?
Yeah.
And did you recommend to him specifically that he not agree to that, or did you let him make his own decision?
I think he made the decision and I was just obviously in agreement.
Okay. Have you ever, in the course of your professional responsibilities at the DOC, had someone from the state police seek information from you about an inmate?
No. Well,
Okay, let's talk about his therapy sessions, okay? Shaking your head, yes?
yes.
All right. Have you ever, in the course of your responsibilities at the DOC, provided therapeutic services to someone in his circumstance as a pretrial detainee?
I want to say yes.
Okay. Do you recall me asking you about this at the deposition?
Yes.
Did I ask you, is it accurate to say, strike that. I'll try to rephrase the question better. Is it accurate that you had never provided services to someone in solitary confinement without a criminal history?
So my answer was this individual did have a criminal history.
Right? You had provided some services to somebody who had been detained awaiting trial, but it was somebody who had already had a conviction.
Yes.
Do you recall us talking about the distinction between inmates who were already imprisoned and commit other crimes and then they're awaiting trial
Yes.
versus inmates like Rick Allen who had never been convicted of a crime and awaiting trial?
Yes.
Do you recall that distinction?
Yes, I do.
Have you ever treated someone in his situation?
No.
And you've treated people, I think you even said you worked at ISP for a while, right?
I did.
ISP meaning the Indiana State Prison in Michigan City.
Michigan City, yes.
Same answer, same question, same answers.
Yes.
Is it accurate to say that most of your contacts with Mr. Allen, just in terms of volume, occurred at that cell door, which you talked about earlier?
Yes.
And that there were times, is it accurate to say that you took him down the hall to engage in a more involved therapeutic endeavor or session?
Yes.
Okay, do you recall us talking about that in your deposition?
We talked about the cage.
The cage, thank you for that. I asked you about what that setting was like, didn't I?
You did.
And is it accurate to say that you told me that there was a cage? I think it was both of our words, but it was just down the hall, a few steps from his cell, right?
It was closer to the entrance to the pod.
How far? Is it farther than across his courtroom, which is,
From his cell?
I'm guessing, 100 and some feet
From his cell or from.
from his cell?
That's about right, to the back of the room.
Same building, same pod, right?
Yes.
Okay, and are the dimensions of that cage roughly about 3 feet by 3 feet?
For the cage area?
Yeah.
Maybe.
Well,
I never measured it.
okay, fair enough. So we were sitting in my conference room and you said about half the size of the table, right?
Yeah, I mean, sometimes they sit down so there's enough room to kind of sit and spread your legs out.
About half the size of this table that's here in front of me. That's probably 7 or 8 feet long.
Yeah.
Fair?
Yeah.
Okay, so a little cubicle.
Yeah.
In this case, it's triangular, right?
Yes.
So I should not be mincing my words or mixing. It's a triangular cage,
Yes.
which has concrete walls on both sides. Is that accurate?
Yes.
And it has a little grate or a gate in the front.
Yes.
Is the gate from floor to ceiling?
Yes.
Okay, so is there a hole in there, like a cuff port, where you can look through?
Yeah, you can see them through the grate, and then there is a cuff port they can open.
Okay, so you just look at him through the grate?
Yes.
Okay, that's where you did your therapy, right?
Yes.
There's also a cage down in Wabash Valley where he's housed presently, theoretically, in the area where they do therapy. Is that right?
Yes.
Did we talk about that cage?
We did.
Is it even more of a traditional cage than the one you use,
It was a freestanding kind of thing.
with four sides with bars, right?
I I think so, yeah.
Kind of what we would envision as a traditional jail cell door with vertical bars, right?
Yes.
Basically sitting in a room, right?
Yeah.
Concrete room with concrete walls.
Yeah.
That's the kind of therapy, or that's the type of environment that inmates get what they're doing when they're doing therapy, right?
That's what they had at Wabash.
Well, you went down there and met with him.
I did.
Do you agree that there is, in your profession, a significance placed on the therapeutic environment that you offer up patients?
Some.
Ideally, it's in a setting that's a little softer than a prison, right?
Sure.
With maybe some chairs that people can sit on, couches, things like that.
Yes.
Maybe some lighting that makes people comfortable. Is that accurate?
That would be ideal.
Sometimes you even have plant life in the room, right?
Yes.
Okay, that's a little more traditional, acceptable therapeutic setting when you're providing therapy for mental health services, is it not?
In the community, yes.
That is not the type of environment that Mr. Allen was exposed to in your care, is it?
No.
And it's not even anything close to that, is it?
No.
In fact, it's a pretty harsh environment, is it not?
It is.
I recall there being a mention that you mentioned that, well, strike that. You never did any kind of therapeutic testing on Mr. Allen, did you?
No.
And do you acknowledge in the course of your therapeutic endeavors that sometimes there is literature that you can offer up to patients to assist them with their mental health problems?
Yes.
Okay, and do you acknowledge that that literature can be specific to whatever their needs are?
Yes.
And was it routine or I should just ask the simple question. Did you ever provide Rick Allen with any literature for therapeutic reasons?
Yes.
Okay, what was that?
I remember providing handouts on depression and anxiety, the Man's Search for Meaning book, and then the crossword puzzles and things like that.
You recall giving him some colored pencils and crayons?
I don't know if I gave him those,
You told me that's what you do
but I'm also,
sometimes.
yeah, we do. I just don't remember specifically doing it,
Okay.
but we do.
Is it accurate to say that your mental health endeavors with Rick Allen and other inmates at the prison are basically limited to the administration of prescription drugs, conversations with the inmates, and discussing suicidal issues with them?
In a restrictive housing situation where we're limited, yeah.
Yeah, those three things are kind of the big ones, right?
Yes.
And just to make sure on my question, which was a little long worded, you have conversations with
Yeah.
the offender, right?
Yes.
Just like you and I are having here today.
Yes.
And you would also communicate from time to time about the administration of meds, right?
If they are prescribed medication, they'd see the psychiatrist for that.
Okay.
Obviously, therapeutic interventions can be implemented. It just depends on how willing the person is to work with you.
Okay.
So people do different things, but yes, it's a lot of talk therapy. It's pharmacological interventions and just trying to
Talking about suicide.
learn.
Talking about suicide, right?
Well, it's important to talk about suicidal. So yeah, we talk about that to make sure they're safe.
When you met with Rick Allen and he was transported to your cage, was he transported in shackles?
Oh, when he was let into the cage, yes.
So we've talked already today. I don't want to belabor the point, but the box cuffs, the belly chain, the ankle cuffs, the whole 9 yards, so to speak, right?
I believe so.
That's the way he meets with you in the cage,
Yes.
and you're outside the cage.
Yes, I don't know if they ever took off the wrist
Okay.
ones.
Did you ever talk to Rick Allen about the exceptions to the doctor-patient privilege under Indiana law?
I don't think so.
Okay. Do you know what those exceptions are?
Are you just referring about HIPAA confidentiality?
Yeah. Let me ask a better question. There's a doctor-patient privilege between you and Rick, which means you can't talk about anything he says,
Right.
right?
That's the underlying law in this state.
Oh.
Oh, sorry, right.
That's the underlying law in this state and probably most other states.
Yes.
There are exceptions to that rule, right?
Yes.
What are those exceptions?
Harm to self, others, or property.
Any other exceptions that you're aware of?
Other more specific exceptions would be things like if they report drug trafficking, the sexual abuse of a child in the community at present, that they may know about where we have to intervene from the inside, inappropriate relationships with staff.
Did you talk to him about any of those things?
He had to have signed the form with me at some point.
I'm asking you, did you talk to him about them?
I generally do.
Do you know if you talked to him? Do you remember that?
I don't remember doing it.
Okay. And if you did, it would be those things that you mentioned to me earlier.
Yes.
When he's in the cage and you're providing therapy, are you taking notes?
Sometimes.
Are there things when you just don't take any notes, you just listen?
Sometimes, yeah.
And in those cases where you were taking notes, do you generally then, I'll say, reduce those notes to a more formal document?
Yes.
And is that document a DOC document?
Yes. Well, it's in our Centurion system, but obviously it's owned by DOC.
Yeah, I'm glad you mentioned that. I need to educate the court a little bit. I forgot to do this at the beginning. Tell the judge who you're actually employed by.
Centurion Health.
And is Centurion Health or whatever, like the health
Contractor.
care provider for all inmates at the prison?
Yes.
And as an employee of Centurion, why can't I say that? Is it your observation that Centurion basically just has a contract with the prison system?
Yes.
And as an employee of Centurion, do you have like DOC credentials? Do you have a like a name badge or a
I do.
badge that says DOC on it?
It'll still say Centurion on it.
Okay.
Yeah.
Does it say DOC on it also?
Yeah.
Okay. Who do you get paid by?
Centurion.
Okay. And do you have like a 401k plan or anything like that? I don't want to talk about the details, but
Right, those would be through them.
through Centurion.
Yes.
Are you specifically assigned only to the Indiana or to Westville?
We can go to any facilities.
Okay. Well, I mean, where do you?
I'm assigned there, yes. But if they ever needed help elsewhere, we can just go over there and do work there too.
Okay. Have you worked for any other companies other than Centurion since you've been there?
Since I've been there for several years, no. There have been a few switches over time, so Centurion, prior to that, we were Wexford Health.
Okay.
Prior to that, we were Horizon Health. So every 3 years or so, they put the contract up for bid and decide which one they're going to go with.
All right. Do you receive training through the DOC regarding how to, you know, custody and safety and security?
We do.
Okay. Just like all the other DOC employees?
Yes, it's tailored to us, so it's a little bit less since we don't do cuffing and do all the extra stuff, hands-on stuff with the incarcerated individuals. So we don't get that piece, but everything else, yes.
So then back to the note taking. So when you take those notes from the cage session and you reduce them to writing, right, into report form,
Yes, and then it would be into the medical record system.
okay, and those reports, I think you told me, is it accurate to say that you would generate those reports usually within 24 hours?
Usually,
So you have some notes, you go finish your rounds or do some more therapy, you may do some other things, and eventually you'll sit down and prepare a report based on what he told you and what your notes said.
yes,
And sometimes that happened within 24 hours, sometimes that happens beyond that.
yes.
And then what do you do with the notes?
I shred them.
Okay, so you destroy them.
Yes,
And would you agree with me that those notes are the best evidence of what Rick told you at the session?
yes.
Let's talk about Rick's general state of mental health while he was at the prison. Is that okay?
Okay,
Do you recall that when he was admitted to the prison that he was generally proclaiming his innocence?
yes,
And he did that with you routinely.
yes,
And do you recall, is it accurate to say that you observed him as being selfless and very focused on making sure that his wife's needs were met?
yes.
That's a particular note that you made about him. Is that accurate?
It's accurate.
Does that also play a little bit into this dependent personality syndrome that you recognize traits of?
Traits of?
The answer is yes.
Yes,
Do you recall in late December of 2022, shortly after he was admitted, that he was starting to express to you that he was being treated worse than other offenders at the prison?
yes,
And do you recall acknowledging that it was reasonable for him to perceive things that way under his circumstances?
yes,
Do you recall in March of 2023 that he started to communicate to you that he wasn't feeling right in the head and he was starting to struggle with things that were going on in his brain?
yes,
And do you recall him around that time reporting to you that he was becoming depressed and withdrawn?
yes,
Do you recall acknowledging that you weren't sure what was going on with him at that point?
Well, his baseline is generally depression, so at that point, it wasn't too far out of what was normal for him.
Do you recall a specific report, though, that you had mentioned? I'm not really sure what the problem is.
It's possible.
Do you recall reporting that on April 4th of 2023 that his state of mental health was extremely poor, critical, and deteriorating?
What was the date?
April 4th of 2023.
Yes.
And do you recall on that day reporting that he had engaged in recent suicidal or self-injurious ideations,
Yes.
delusions, fatalistic delusions, or fantasies?
Yes.
Do you recall reporting that he believed that death would bring relief to him,
Yes.
that he was hopelessness, that he was hopeless,
Yes.
that he was suffering from some insomnia
Yes.
and poor appetite?
Yes.
Do you recall reporting that he was struggling with self-esteem
Yes.
and other ailments, right?
Yes.
There was a whole laundry list of them, correct?
Yes.
Do you recall reporting on April 12th that his behaviors were becoming more bizarre?
Yes.
And some of that involved banging his head on the wall and kicking doors and becoming self-injurious. Is that the right word?
Yes.
Phrase? And then, do you recall reporting on April 13th that he was suffering from a grave disability? You used those words?
I'd have to read my note to see, but I believe that.
1 second, Your Honor. May I approach?
Yes.
I just want to clarify. Ma'am, I'm doing this the old-fashioned way. I just print this stuff out. Let me direct your attention to part 1 of your deposition, page 136. You want to look at the cover page, so your page 136, and specifically lines 8 through 11.
Right. This was.
Did you tell me he was suffering from a grave disability?
Yes.
Do you recall reporting at that time, April 13th, that he was consuming his own feces
Yes.
and that it was time to consider voluntary or involuntary psychotropic medications?
Yes.
Basically, you got to stick a needle in him.
Yes.
And in fact, he was later approved for that, right?
Yes.
When I say approved, there's a
Committee.
treatment plan or treatment team that meets
Yeah.
and says, okay, we need to stick a needle in him.
Yeah.
That's what
Yes.
happened
Yep.
more than once.
There's a distinction between emergent and voluntary and involuntary. So his would have been involuntary, where we went through the hearing and everyone agreed that this would be a normal injection he would receive every 2 weeks or every 4 weeks. Emergent, I believe he also received. This is more of a one-time thing. So when he was banging his head and he wouldn't stop, that is when we would give him a shot just for that one incident.
Is there any distinction of the type of needle you stick in him?
No.
It's all the same, right?
Yes.
Okay. Do you recall April 21st articulating in your medical records that he might be incompetent to stand trial? You had that discussion with him?
We talked about it, but I think I was just trying to explain it to him because obviously we can't make that determination. We are not the ones to make that determination.
Okay, you had that conversation with him, right?
Some kind of conversation about it, yes.
Well, to be fair, I'm gonna let you review our conversation. Let me direct your attention to page 154 of part 1 of your depositions, specifically line 10. You see that through 14?
Mr. Rosie, what date of her report is that referring to?
Let me go back and look here. Would you hold this for a second? She acknowledged that it was April 21st.
Sorry. Oh,
Sorry.
no, yeah, so.
Do you recall having this discussion with him about the fact that he might be incompetent to stand trial?
Possibly. It's kind of vague. I mean, I know we've touched on it, but it was more so allowing him to know that that's not going to be something that we would determine at the facility.
Okay, so the question I asked was, and then in the next paragraph down, you were engaged in a discussion with him about, hey, You might be incompetent to stand trial. That might be one of our evaluations moving forward. And your answer is, yes, I did say that, right?
I guess so.
Okay. I mean, we don't have to mince words, but you had that conversation with him
There was a conversation.
because you had a belief that that might be the case.
The way things were going at that time.
Very good. Thank you. Do you recall reporting that his thoughts were disjointed and that he was saying bizarre things?
Yes.
And that on May 3rd, do you recall reporting that he said he wanted to confess?
If that's what I wrote, yes.
Okay. And that he started telling a story about how he did the crime.
Yes.
And this occurred when he was in the cage.
Yes.
And are you pretty sure that you wrote some of that down?
Yeah, I think I wrote some of it down.
And you would have destroyed those notes too?
Yes.
Is it accurate to say that you reported in your medical records or your psychiatric records that it was difficult to tell when he was being honest with you and when he was not
There were times I questioned it.
during this April timeframe
Even then,
and in May 2023?
yes.
Do you recall reporting that in May 17th of 2023 that there was an increase, a slight increase, you said, in his disorganized thinking and paranoia?
Yes.
And then on May 18th, you reported that there were more injections. Does that sound accurate? We're into May now.
If it was his next routine injection, maybe.
Okay, do you want me to show you my questions here
Sure.
just to make sure we're accurate? Page 177 of the deposition. Let me find that reference to the date here. Sorry. Looking at page 176, line 22, it references May 18th, right?
Yes.
An entry at 5:48 p.m.
Yes.
or maybe a.m., I don't know.
Probably PM.
5:48 is what it says, right?
Yes.
And then the continuation of that conversation on page 177.
This is referring to he was just due for his next injection.
Okay, so around that time he was due, right?
Yes.
Injections are pretty rare at the prison.
Is that a question?
Is that? No, it's not. It is a question. It's a poor question. I withdraw. Are injections pretty rare at the prison?
Numbers wise, I mean, yeah, it's not common.
Is it?
We have them, obviously, but it's just maybe a dozen people at most out of 3,000.
Say that again?
A dozen people out of 3,000.
Did you tell me that it might happen once a year or something like that?
So that's more of an emergent situation
Okay.
where someone's actively engaging in self harm and must be stopped in that moment. So it's like a one time shot.
Which we had here.
We did also have that.
Okay, so these are the most severe consequences in terms of intervention. Is that accurate
Yes.
in the mental health field?
With the exception of
In that setting.
restraints. We didn't do restraints.
Okay. You recall telling me that, or do you recall reporting that on May 18th or at or around that time that he was ramming his head into the wall?
Yes.
You recall there being a report on May 22nd, 2023, that he was having breaks of psychotic reactions to stress?
Yes.
Do you recall reporting on June 8th of 2022 that his depression had reached, that obviously is supposed to say 2023, that his
Mhm.
depression had reached its peak or was at its peak,
Yes.
and that he was suffering from psychological symptoms such as trembling, knees buckling, and stuttering?
That was happening. Yes.
Do you recall that, well, a report regarding June 16th that you hit him with another injection, that he was injected again? Make sense?
If it's a monthly injection, yes.
And then finally, on July 11th of 2023, do you recall reporting that you started to see some sign that his mental health was being restored?
Yes.
You said to a normal state.
Yes.
Okay, so he's coming out of the funk, as I referred to it, right?
Yes.
You recall suggesting that, hey, he might be finally adjusting to incarceration at that point.
It was a theory.
That's an explanation.
Mm-hmm.
Yes or no?
Yes.
And that's based on your medical training and your experience of dealing with offenders at the DOC.
Yes.
That was 8 months after he was admitted, right?
It would be.
Do you recall noting that even after his adjustment started, you saw some psychological conditions in terms of the way his eyes looked?
I did write down anything I noted that was strange.
Yeah, that his eyes were bugging out of his head at one point, right?
Yes.
And that you thought that was significant enough to report.
Yeah, I reported it.
And then there was a report generated on November 22nd of 2023, a discharge plan referencing his suicide watch for the past 6 months. That would be accurate, right?
Yes.
And there was a reference to his earlier stress-induced psychosis. Those were the words.
Yes.
And his vegetative symptoms of depression, right?
Yes.
All the things that were going on in March, April, May, June of 2023.
Yes.
You recall that even in October, you were still having some therapy sessions with him in the cage.
Yes.
October of 2023, right?
Yes.
And that he was proclaiming his innocence at that point.
If that's what I wrote, then yes.
Okay, well, do you want me to show you the deposition?
No, I believe you.
Okay. Do you acknowledge that he communicated to you that he had already been sentenced for this crime?
He made comments like that.
And do you acknowledge that in late November he started to regress again briefly into a more depressed state?
Yes.
Do you recall during that time that you reported that he was escorted from his cell while these inmates continued to yell at him?
Yes.
You made a specific note that day that, hey, they're badgering him, right?
Yes.
That's my word, not yours, correct?
Correct.
Calling him the same kind of names that they had earlier.
Yes.
Now, there were other psychiatric reports that were prepared by the treatment team and by maybe Dr. Martin,
Yes.
if I'm not mistaken. Is that right?
That's right.
And those notes are notes that we went over in the deposition. Do you remember doing that?
I don't know how much we went over Dr. Martin's notes.
Who else would have generated notes? I'm just trying to remember.
We were supposed to not talk about the ones that were done in conjunction with DOC,
Okay.
the MDTs.
Because there was a lawyer there when you were doing those.
Yes.
We had to have a lawyer sit and meet with you during these treatment teams, right?
Yes.
Was that unusual? You had a lawyer in the room when you're in treatment team?
I mean, in my experience,
Okay. Rick was a unique situation, right?
he was.
So do you acknowledge that some of those psychiatry notes mention that he had an abrupt onset of psychosis and abnormal behavior,
Yes.
and that there was a psychotic process occurring?
Yes.
That was the phrase, right?
Yeah.
And we're talking again about the March, April, May, June-ish time period.
Yes.
So he's been diagnosed as being psychotic during that time.
Yes.
And that's one of the reasons why he got the involuntary injections. Is that accurate?
Yes.
And there are other reports that say similar things to that, right?
Yes.
Medical or psychiatric reports.
Yes.
There was a report that we talked about where he was observed as having disorganized speech, grossly disorganized, and catatonic behavior, right?
Yes.
And that was during
Yes.
the same time. That was during the same time frame.
Yes.
And there was an acknowledgement that in one of the notes that he was identified as having a serious mental illness from a clinical standpoint, right?
Yes.
Now let's talk about that. We talked about what serious mental illness is and the technicalities of that when I deposed you. Is that right?
Yes.
So SMI is a specific diagnosis or designation within the prison psychiatric vernacular, right?
Specifically to the individuals that are in restrictive housing.
Okay.
So if they're, we can generally say someone is SMI and we know what we're talking about, but when they go into restrictive housing, generally things change for them in terms of frequency of visits
Okay.
and how long they can even stay in restrictive housing.
All right. And we'll get to that. Thank you for that. He was identified as being seriously mentally ill while he was at the prison, wasn't he?
So I know that came up in one of the MDT notes. I don't know if I'm supposed to say anything about that.
Hmm. Let me just try to get to the point here. He met the medical, strike that, he met the psychiatric threshold for being seriously mentally ill, but you designated him as a safekeeper in the DOC because of this court order, right?
Yes.
So let's separate. I'm going to ask you questions about you as a doctor over here, and then I'm going to ask you questions about the technical aspects of being a safekeeper. Do you understand that?
I think so.
So, from a psychiatrist or psychologist standpoint, which you are, he met the criteria for serious mental illness at a time when he was at the prison.
Yes.
No doubt about that, is there?
No doubt.
But he was designated by prison administrators as being a safekeeper. Is that accurate?
Yes.
And so, by receiving that designation, he then was removed from the SMI designation,
Yes.
correct? But then so they basically have a box on a form that says safekeeper, and they check the box and say he's a safekeeper, right?
Yes.
I mean, at the most basic level. Agree with that?
I agree.
Do you agree with me that that doesn't change what's going on in his brain because they identify him as something else, right?
Right.
He's still suffering from all the same things.
Right.
He just doesn't get the same treatment as somebody who would be seriously mentally ill because of this designation.
Right.
Okay. Now, the phrase serious mental illness or SMI in the DOC is one that you are very familiar with, aren't you?
Yes.
And is it accurate to say that when someone is identified as being SMI, that there are very strict timelines on how long you can detain somebody in solitary confinement?
Yes.
Is it accurate to say that that strict timeline is 30 days?
Yes.
And is it, as a psychologist, do you agree that the impact of solitary confinement on a human is something that's been widely studied in your profession?
It has.
And do you agree, well, you don't have a subspecialty of that phenomenon, do you?
No.
I think we actually talked about that, right?
Right.
But you're familiar with that because you work in a prison,
Yes.
kind of hands-on training, right?
Yes.
Or experiences. You're shaking your head, yes?
Yes.
Thank you. We agree, strike that. I didn't ask Warden Gallipo this, but they call this place where Rick was detained the hole, don't they? That's what inmates call it.
Yeah, some of them call it that.
Do you agree that locking someone up in the hole is not a good way to promote positive mental health?
I agree with that.
And do you agree that it's not a form of mental health treatment that exists in your profession,
It is not.
and that it, in fact, can have a negative impact on somebody's mental health?
There's a possibility, yes.
Somebody who's suffering, do you agree that it can have a negative impact when somebody especially is suffering from pre-existing mental health problems?
Sure.
Do you agree that Rick suffered from pre-existing mental health problems?
He did.
Diagnosed as having major depressive disorder at the doorstep of Westville, correct?
Yes.
Do you agree that you would never use solitary confinement as a tool to help improve someone's overall mental health?
Not their mental health.
30 days is the threshold, right?
There are exceptions to the 30-day rule.
Right. When somebody puts a hat on you that says you're a safekeeper, right?
No, I wasn't referring to that. There are individuals who remain in restrictive housing beyond the 30 days if they're deemed to be too dangerous to be out in the general population.
Oh, because they're just physically a danger to others, right?
Yes.
Rick Allen does not meet that exception, does he?
No.
And do you agree that Rick stayed there for more than 12 months?
Yes.
12 times the 30-day threshold?
Yes.
Do you acknowledge that if someone's mental health is poor, putting them in solitary confinement for long periods of time just makes it worse?
It can. It can.
It does, doesn't it?
A lot of times it does.
And in fact, there's a lawsuit that was filed between the Indiana Department of Corrections and IPAS. Are you familiar with those phrases?
Yes.
I think IPAS is the Protection and Advocacy Service or something.
Judge, I'd like to object. We're so far beyond what the subject matter of this particular motion is. Her knowledge of a lawsuit with IDOC has no bearing on whether Mr. Allen was coerced or induced by his environment to making statements that are incriminating for this trial. And so I've waited and waited as to allow as much questioning as I can, but I just don't think that we're focusing on the point here, and I would ask his questioning be limited to the issue.
May I?
Certainly.
Judge, I laid out at the outset, I explained to the court that there would be due process arguments being made here, Fifth and Sixth Amendment arguments regarding the circumstances under which he was detained, and this is directly relevant to those. What you're going to hear is that she's already said the DOC has policies on the length of confinement that one should endure when they have serious mental illness. And she will testify, if I asked her two more questions, that those policies arise from the settlement between the Indiana Department of Corrections and IPAS. Specifically, stem from the language in those in the court order in the United States District Court, Southern District of Indiana, Indianapolis Division, presided over by the Honorable Tanya Walton Pratt, and in the 2016 settlement agreement between the two. That's why I think they're relevant.
Judge, I would renew my objection. It still has nothing to do with whether Richard Allen is being coerced or induced by his environment to make statements against his own interests. It's not relevant. I'll sustain the objection.
May I make an offer to prove?
You may.
Ma'am, I'm going to try to do this in more summary fashion. Actually, I could just offer up the exhibits. Ma'am, what are we on in terms of letters?
T.
T. Okay, thank you. If I may hand you on this exhibit T and U, T being entitled Entry Following Bench Trial of United States District Court, Southern District of Indiana. Oh, you know that, I'm sorry. I think that's follow. Just give me a second here. Let me get another sticker.
Uh-oh. The court reporter can put stickers on there for you, sir.
Uh-oh.
Yeah. I think we're going to pause here for a second, chat, just because I think we're having some technical difficulties. So give us just a second, and we'll get back on track.
Can I say something about iPass T?
Yeah, absolutely. So,
Okay.
Off the court record.
We are off the record. So what they're talking about here is actually really important. I don't know if it's important to Judge Gull. It probably wouldn't matter how well they argued it, but this lawsuit case that Rosie is citing and now making an offer to prove about was IPAS, the Indiana I have to sneeze. I'm so sorry. Okay, it's not happening. Indiana Protection Advocacy Services, basically like ACLU, similar kind of organization affiliated that advocates for prisoners' human rights, right? Civil and human rights of prisoners. And the Department of Corrections of Indiana, on the whole, was sued in a class action lawsuit by a bunch of prisoners in addition, or like in, concert with IPAS. And they actually, quote, won, meaning Indiana Department of Correction had to settle in that case. And it was a huge settlement. And what ended up occurring as a result of that settlement was that the court found that DOC was violating the constitutional and civil and human rights of the inmates, especially by keeping inmates with serious mental illness in solitary confinement and restricted housing for more than 30 days, basically neglecting to even give them like an hour of rec a week, let alone, doing anything conducive to like mental health improvement. So the court basically told the parties to like implement interventions and changes and everything. So the Department of Corrections had to basically totally overhaul their policies, especially as it relates to restrictive housing, which is solitary confinement, the whole. And they have all of these definitions that they had to abide by in terms of what constitutes serious mental illness, what they are and are not allowed to do with prisoners who are considered to be seriously mentally ill. And there's like a very hard line of you cannot keep a prisoner who is seriously mentally ill in solitary confinement for more than 30 days. And then there's also a bunch of other things they're supposed to get, like without exception, that obviously they were not getting. So this, I can't remember how many years this settlement was in like active for, but basically the agreement was that DOC had to maintain these policies. Inmates had basically an avenue for reporting and holding DOC accountable. There were people that they were able to directly like complain to, affiliated with IPAS, who would then, there were like checks and balances basically, and DOC was accountable to IPAS and their, attorneys or whatever oversight that was. And so that really protected, as well as they could, as well as it was actually, I don't know how like much fidelity it was implemented with, but I think it really did end up resulting in a lot of changes in DOC. And it was a time limited settlement though, right? So DOC makes all these sweeping changes and they're like improving mental health of prisoners. And IPAS, they reevaluate the settlement, the court does with the parties, and like they renewed it one time for 2 years. And when it was time to renew it again, they're like, well, let's just see, check and see how we're doing. So they're like, you know what, DOC, they found their groove. The problems and issues that we sued over seem to have been rectified and, sustained, the improvements and the interventions have been sustained. And so we see no reason to extend or renew this, agreement. And so we will terminate it because now DOC is basically, we're trusting DOC to like continue to uphold these standards that they've implemented as a result of this lawsuit.
When is
So
that happening? Hold on, and
the
when is that
date,
happening? What date is
well,
that they're saying, okay, we're going to just release it and not worry about it because it looks everything
April 13th, 2023, the very day that Richard Allen gets emergent injections of Haldol, and the very same fucking day that the treatment team meets to discuss his placement. Same day.
Same day.
And then Nick lies about
Yep.
that
He
meeting.
gives the wrong date. He says 2021. But I mean, they don't correct him though. So we know he's
And he
going to
says that
lie.
Did they not know that at the time?
No, because they knew, because they had already made this argument. Actually, so Nick files a motion in limine, and he includes IPAS in it and says they're not allowed to talk about IPAS during trial. And he said he gives the date as 2021, which was after this hearing. So he knew the date, but in the objection to the motion in limine, I don't remember. I don't know specifically what the defense responded to, but at no time do I remember them correcting that. And that's a huge, in my opinion, misrepresentation, because the fact that it ended on the very day that they're holding this important lawyer clad treatment team meeting about Rick's placement as to whether or not they're going to violate the policy, and the very same day the policy is terminated, like that to me feels like a pretty relevant thing. I don't know that it's relevant to I don't know what it's relevant to. It just feels important,
Well,
Anyway,
I mean, this is
that's
one
my
of those
tangent.
circumstances of how many coincidences before it's not a coincidence. So if this was like the only oddity in the thing, we'd be like, okay, it's probably just a fluke. It happened on the same day, right? I mean, like that we could watch, but there's so much when it comes to just even surrounding this safekeeping order that's in question and the dates that align with other things that I don't think you can overlook it. Is it relevant to Judge Gull? Well, nothing is relevant to Judge Gull unless
Exactly.
he says it. So
Yep. But that policy would have, presumably, I mean, at that point, they had already been violating it from whenever Rick got there up until August. Like, so basically, they had already been violating for 5 months. But had the policy been in place, I mean, it could have been argued at the safekeeping hearing a few months later that he needs to, at the very least, be taken out of restricted housing. Not that they would have listened, but ideally. So, Westville, oh, I forgot this part, and then I'll stop. Westville is not even one of the facilities that is equipped or appropriate for somebody who is that class, what, E, which is like the
yeah,
most acute mental illness, which Rick would have 100% fallen into that category. But that would have meant that they would have, by the policy and by the court order, they would have had to move him to either Pendleton or Newcastle, or I think the other one is
yeah.
Pendleton, the mental
And
health
like
equipment.
I struggle with that because how does the safekeeping order trump his mental health if his
Right.
mental health isn't keeping him safe? Like how, like
Right.
that just does not make sense to me. How
Right.
does marking safekeeping on there say, okay, that's now become the most important thing, irregardless of anything that he does to himself that is not safe? Like we just
Right.
don't care. Like it's okay if he hurts himself because then this whole thing's done and we don't have to pay anymore.
Well, then you have to also consider who is this meant, like what purpose does this serve, and who is this actually meant to benefit? Because it's
Mm-hmm.
obviously not for Rick's benefit.
Mm-hmm.
The safekeeping order was not for Rick's benefit. From day one, it hasn't been for Rick's benefit, and it never was, and it continued to just be to his detriment exclusively. That safekeeping order was 100% to the benefit of the state of Indiana and Jerry Holman. That's it. That's it.
I agree with you. No.
But it's a good question, T, and it shouldn't trump it in any circumstance. But
All right, so are we back on? Rosie, did your mic check out?
I think.
Okay,
I
and then
think I think my Wi-Fi went out.
Trav, are you going to switch to Diener or do you want us just to keep reading Diener? I mean, I can read Diener; it's no big deal.
At your pleasure, whatever you want.
Okay, that yeah, because it's my fault. I messed that up, which is it's not surprising in the scheme of my life. So if you wouldn't mind switching, that would be great. And then so when Diener pops up with her objections and stuff, I thought it was Nick today, and it's not Nick, it's Diener, and so I screwed that up.
It doesn't matter. That's fine.
Okay,
Okay.
so we'll go back.
Yeah.
We'll go back on the record then at we're on volume 5, page 136, line 2.
Okay, I'm sorry.
The court reporter can put the stickers on there for you, sir.
Thank you. I was giving you my copy. I didn't mean to do that. Handing you T. Is this a copy of the order form, court order from the Southern District under, let me read the case number again into the record. 108CV01317 TWP MJD Indiana Protection and Advocacy Services Plaintiffs versus Commissioner, Indiana Department of Corrections. Is that right? That's Walla.
Miss Walla, I think you may have accidentally hit mute on your mic. There you go, love.
oh, is this me?
Mm-hmm.
Yes.
Oh, okay. I thought he was doing off. Okay, I'm sorry. Yes,
Okay. And then it's all right. I understand. I'm just reading. Is that what I'm reading off of?
that's what you're reading. Yes,
And that's what it says.
yes,
And then on the last page, there's a signature here, December 31st, 2012, the Honorable Tanya Wilton Pratt, Judge, United States District Court, Southern District, right?
yes.
Okay, and do you acknowledge that this is, and you can take a look at it, this is a court order that pertains to the settlement between to the trial between IPAS and the Indiana Department of Corrections.
I don't think this is proper offer to prove. I think you could admit your exhibits as part of your offer to prove, but I don't think having her testify about something
Okay.
like to that extent.
I didn't know if you wanted a foundation, so.
No, if you want to make an offer to prove, make your offer to prove.
Well, I do want to make an offer to prove Exhibit 1, and I'm also asking the court to take judicial notice of the document because it is a finding by the Southern District of Indiana. Thank you.
So purposes of the offer to prove, I'll show that T is admitted.
Is the court taking judicial notice of that document?
I will take judicial notice of your offer to prove containing in Exhibit T.
Very good. Thank you. And then second, right here, has this been marked? That's the wrong one here. Thank you. Offering defendants U, which is titled United States District Court of Indiana, Southern District, Indianapolis Division, Indiana Protection and Advocacy Services versus DOC, stipulation to enter into private settlement agreement following notice to the class and fairness hearing. This document is signed by parties for both sides and it's dated 1/27 of 2016. I'll offer that up, Judge.
I'll show you is admitted to. Is this the completion of your offer to prove?
Well, I'm going to summarize why I think they're relevant.
Then I will show T and U admitted for purposes of the offer to prove.
Did I just give you the wrong U?
I don't know what you gave me. You gave me for purposes of an offer to prove. It's your offer, not mine. I don't know what you gave me.
I'm just making sure I gave you the right thing. Judge, with regard to T, on this particular document is an entry of judgment after a trial occurred to the bench regarding the settlement. I will direct the court specifically to, give me a second, specifically to page 5, section D, page 6, page 7, page 8, page 9. And in those sections, the relevance is that Judge Pratt identified with specific bullet points the various conditions that existed with regards to the inmates in this particular case, the findings of fact, if you will, many of which mirror the conditions that exist in our case. For that reason, I would identify and I would direct the court to page 10 and 11. On page 10, there's a specific definition for the terms. I'm sorry, there's a reference on page 10 to the DSM-4 and the Axis 1 diagnosis of major depressive disorder and other disorders, all of which fall within the serious mental illness or seriously mentally ill definition that was adopted by the court in this case. And I think those are relevant because they set the standard for when Ms. Walla is seen with her patients and how those patients are handled from a detention circumstance. And that's the purpose of the admission. Without belaboring the rest of this, Judge, it's a very long ruling, 37 pages. And there are other parts of this ruling that I've highlighted for the court in misdemeanor that I also believe are relevant to the findings. I'm not going to go through those today. The highlights are there, and I think they're relevant for the purposes. The information that's offered up is relevant to our proceedings today. Second, Defendant's Exhibit U, this particular document is the settlement agreement that stemmed from the court's order in 2012. I think if you read into the document, you'll see that it's relevant because what happened is that basically Judge Pratt said, shame on you, DOC. You violated the constitutional rights. I'm going to issue any damage order, but give the parties some time to figure that out. We'll come back if we need court's assistance. And then eventually they figured that out. There were damages, I think about $500,000 paid out by the DOC. The relevancy is page 4. On page 4, there is another designation of the phrase, or there's a determination of what the phrase seriously mentally ill means, a definition, if you will. And it's relevant for that reason. So that's the request for judicial notice. Thank you.
Okay.
Or the offer to prove, I'm sorry.
Thank you.
1 second. Ma'am, you acknowledged that I talked to you earlier about there are some statutes regarding privilege, doctor-patient privilege.
Yes.
Okay, I'm going to hand you Defendant's Exhibit V. Just take a look at those two statutes without rushing too much. Does that first one look, the privilege statute that basically says there's a doctor-patient privilege in Indiana?
Yes.
Yes or no?
Yes.
Second one, it's got the exceptions listed there, 25-33-1-17. You see those?
Yes.
And you acknowledge that one of the exceptions, specifically subparagraph 1, is that communications between doctor and patient are not privileged in cases where there are trials for homicide when the disclosure relates directly to the immediate circumstance of the homicide, right?
I see it.
Not one of the discussions you had with Mr. Allen, right?
I don't know. Would it not pertain?
Well, I'm saying you didn't have that discussion.
Oh, no. Mm-mm.
In other words, you didn't inform him of that privilege,
No.
that exception to privilege.
No.
If the court will take judicial notice, but I'm just for the sake of...
Do you have any objection to V? They're statutes. I have no objection. Okay, I'll show V is admitted without objection.
Can we go off the record for just 1 minute?
Yeah, absolutely, Miss Diener.
Oh, shit.
I'm going to change the name, but during the offer of proof, when he's reading the consent decree and order decision from the Southern District, talks about a payment of $500,000 out to that entire group. The DOC had to pay about $500,000. I don't know how many inmates, prisoners were involved in the lawsuit, but probably didn't break down to a lot per plaintiff, per individual inmate. But this goes to, and I just wanted to point out about when we were talking, Michael Osbrook and I, months and months ago, about how great it would be if a civil suit could have been filed on behalf of Rick for the same type of treatment. It wasn't for a big payday, as I think somebody kind of mentioned out there in the ether somewhere. A $500,000 case for 30, 40, 50 inmates, it's not a big case. The civil suit would have been filed because the issues about how he was kept, how he was treated, how this committee met, this committee had an attorney that attended, all of that was fair game. And so while it was there, I wanted to bring out the fact why at least Michael and I thought that a federal civil suit for the way he was kept, which, remember, Rosie filed a notice of claim for that at one point Judge Gull thought was a breach of ethics, and then her attorney promptly dropped that when they argued it in the Indiana Supreme Court as a basis to remove Baldwin and Rosie. But while we were there, and that $500,000 payment that was just read, and that great explanation of the suit that we heard, wanted to bring that up, and that was it. And I'll get my name changed before we get to that. But I don't know if anybody had any comments on that. But that's what the whole civil suit was going to be about.
Okay, so what are your thoughts on this lawyer being involved in these communications? Like, is Richard not there, or is he there and there's this lawyer for either Centurion or the DOC? I couldn't determine which one.
Yeah, so that was part of the testimony earlier. Rosie's asking, okay, now it was in the context that they met in a committee, and they were talking about Dr. Martin. You all will know more about what Dr. Martin's involvement was, but and then Rosie asked, well, is there any other notes? And then she said, well, we weren't supposed to talk about the meetings, the MDT meetings, whatever those were. And then Rosie asked, that's because there was an attorney there from DOC. And I don't know if they had an attorney from DOC regarding those meetings as a result of the consent decree order, or what, or if that's something they always did. I kind of suspect, given that it was the same day, but maybe not. It may, we just don't know. But it appears pretty clear that these are not treatment sessions with Rick. They're this committee meeting, and they had a DOC lawyer there. I've never ever heard of that. You're having a meeting among medical, psychological, healthcare professionals to discuss the treatment of a patient inmate. I've never heard of a lawyer being there, but
well, like the lawyer's there to make sure they don't cross the legal line, is what it seems like to me. That's why I'm trying to figure it out. Because...
Right, and so I do think, given we found out, and I love that excellent summary we got about the order and this judgment that came down right when they were starting to do whatever it was, coincided with that date. I'm pretty sure that they started to have meetings with an attorney, and it was probably for the purpose that these meetings were on a group of patients that fit the criteria of the order, that from this day forward, you're going to start to do these things. And on those consent decrees, the court will establish reporting timeframes, annually, quarterly, and that you have to put all of these different things in a report. And so the attorney would be there to make sure that all of the things are covered. But that's what I think it's about. But then there's a question Rosie asked. So this was an unusual, have you ever seen that before? No, not in my experience, Walla answers. And so Richard Allen was a very unique situation, wasn't it? Yes, it was. So I can't tell, Teresa. It's, there's only about 5 lines about an attorney being present in the testimony. It was about 4 or 5 pages ago, but that's all I can tell you. But very, very odd, without a doubt. But I did
like I said, my first thought was just like, do they have this attorney there in order to say, how far can we go before we are back in another lawsuit?
Yeah, you could read it either way. I put the testimony in the our backroom chat here. It's so question, what else would have been noted? I'm just trying to remember. We were not supposed to talk about the ones, plural, that were done in conjunction with DOC. Okay. The MDTs, I don't know if anybody knows what that is, because
I think he said it.
There was a lawyer there when you, question, because there was a lawyer there when you were doing that. Answer, yes. Question, we have to have a lawyer sit and read and meet with you during these treatment teams, right? Answer, yes. And
So I guess they're referring to like privileged stuff, since there were lawyers in the room, since Nick has tried to say since he was present in a room when conversations were happening that it was privileged.
So if Rick's not there though, so it's like an attorney for the people who are there in order to, this is what Ariel was asking in chat too, in order to make it so that that whole entire conversation becomes privileged because an attorney's there?
Yeah, it sounds like that.
That could be the reason for that.
Okay,
if you remember,
I have another question about this. can somebody, so because of my predetermined thought process regarding these people already, can somebody, Travis, Sleuthy, whoever, tell me, or anybody in chat, tell me a legitimate thought process on why this attorney should be in there that is not nefarious?
Well, technically, the DOC covering their asses with attorneys isn't necessarily nefarious to me in and of itself. I would expect it. Like, I would assume they have a legal department for that specifically. Um,
I think the fact that Rosie pointed out and got her to testify, because again, this was in the context. That first question, was there any other notes that we talked about? What the context of that is in the deposition. Did I ask you about any other stuff? Did we talk about any other stuff? And then Sleuthy's right says, well, there was those treatment meetings that were conducted with DOC, and we weren't supposed to talk about the ones that were done in conjunction with DOC. I couldn't tell if she was saying, I'm not supposed to talk about those because they're covered under privilege, or if she was not supposed to make notes of it. But I think, Sleuthy, you're right that we weren't supposed to talk about those in the deposition. And then because Rosie jumps on it and says, you ever seen that before in your professional experience? An attorney in on treatment team meetings? No. Richard Allen was a special case, right? Yeah, I'm paraphrasing. I think
Yeah. Okay. See, so like if they
he's
can,
bringing that up, that's for a
his what?
nefarious, yeah, it's for a nefarious reason, is what Rosie's implying clearly to me. That she'd never ever seen that before. They had treated Rick with the injections. They had treated other inmates with those. So it's the reason there was a lawyer in the treatment team meetings was because of Richard Allen, not because of anything else, is the way I take that. And he's bringing that out because it's unusual, so that's highly suspect. And I agree. And then unless there's some reason for that, maybe because he's under this safekeeping thing, and that's what they would argue. The attorneys, the state attorneys for the prison system would say, well, this was under a safekeeping and there's different criteria for that. And so we had to be ensuring that all of that was met. But we'll probably never know. But if, we'd gotten the go ahead to file a civil suit, we would know the answer to those questions.
That's
and we
true.
would know if there might be some good fodder for post-conviction, because we'd have that discovery would be clearly relevant. And that's what the purpose of a civil suit against the prison system was. It wasn't on behalf of Rick, wasn't because of a big payday. Probably wasn't going to be any payday.
So even if they were
But
to
Sleuthy, I think you had a couple other comments.
did I?
I know, so I was saying, like,
I thought I had interrupted you.
Like, it was probably just me. So if they say that it was just Rick Allen, like the other inmates don't have this attorney there, they would be able to just like turn it around and say, oh, hey, it doesn't really matter because we did it because Rick's a safekeeper. and we wanted to just have our bases covered and to cover if there was anything nefarious happening.
Well, and again, it's my speculation. I don't want to go as far as say it's an educated guess, knowing me, blind pig, law dog. But we know that in other hearings that it came out very early on that the warden and some others, the sheriff, maybe you all would know better than me, that was part of the discussion. Have they ever seen this type of situation happen? Somebody who's awaiting pretrial with no criminal history being put under a safekeeping order. That was done before, but put into a medium or high security prison. I think the testimony was no one ever had heard or seen that before. And so if I'm the attorney for the prison system, that would be my argument that, yeah, normally this doesn't happen. They go to a county jail and get mental health treatment. This was kind of a first for us, and so it needed to make sure. And then they could bring in the civil suit that they just settled as part of that. We had just recently came out on the losing end of a civil suit, and we wanted to make sure that we were in compliance with everything moving forward because we're conscientious people, and
I like that you can't even say that in regards to these people without chuckling.
Yeah. So,
all right, we'll get back. We can go back on the record. We have our witness is back from her hiatus.
Okay, I'll try and get my name changed. But
no, I already did it for you, Travis. It let me do it for you.
So I created the off the record conversation for the banner on the bottom, and then I'll switch it back to.
Put a picture of a really, really attractive attorney on there too.
I don't think I can put your picture. I don't think I could change your picture, but I can. Wait, maybe I can. I can change your name.
I don't think you can do pictures. You can't change his avatar.
No, I can't.
All right.
Okay. So we are on volume 5, page 139, line 9.
No.
Can we go back on the record, Your Honor?
Yeah, we're
141. Isn't that what I said?
You just had you're right. You just had them backwards. Yeah, it's page 141.
141, page line 9. Yeah. Yep. Okay.
We can go back on the record, Your Honor.
Okay. Back on the record. Here we go.
Hold on, I'm going to change my...
Off the record again.
Well, can you still hear me?
Yep.
Yeah.
Okay, so 41, 9?
Yeah.
You have certain professional standards under which you practice medicine or psychiatry?
Psychology, yes.
I'm going to mess that up forever. Psychology?
Yes.
And those standards are set by the APA?
Yes.
American Psychological Association, right?
Yes.
Do you agree that one of those is a code of conduct that exists?
Yes.
I'm going to hand you what's been marked as... Judge, I failed to make a copy of these, so I'm just going to lean in here for a second, if that's okay.
Well, do we need to take a break so you can make copies? Is that what you're...
Yeah, we can do that. It makes sense.
All right.
Or we can do it after, too. I'm fine with whatever.
Okay, just go ahead and take your break. Make your copies. All right, we'll take 10 minutes then. Let's be back. 3:10. Okay, we are back on the record. All right, are we ready then to continue?
Yes, Judge. Judge, I'd like to renew my request to admit Exhibits T and U, and this is the reason. I've just thought about this when I was in the hallway. We're also litigating this request for admissibility that was filed by the state as it relates to Dr. Walla's records. It's Mr. Allen's position that he treated in a manner inconsistent with the guidelines. That's odd. We're making those arguments today, and that the product of that treatment, because it was inconsistent with the guidelines, should not be admissible. So I'm asking for the court to reconsider the admissibility of those two documents with that umbrella of that admissibility request by the state pending, which frankly I kind of forgot about, and it seems part and parcel to all of this. Thank you. Otherwise, I'm ready to proceed with questioning.
Judge,
It's okay. Go ahead.
Judge, 1 minute. I need a sip of Dr. Pepper. 1 minute. You have to excuse me, Your Honor. I fell asleep last night with my mouth wide open underneath a ceiling fan. I have a deep, gravelly voice this morning. It just sounds terrible. Let me get my Dr. Pepper here.
It's okay, Miss. It's okay, Miss Diener.
I'm pulling up my notes on my fancy laptop, and here they are. Just a second. Okay, I'm good to go now. Let's see here. Okay. All right. Let's see. Where was I? They're talking about this deal in.
We're at volume 5, page 142, line 22.
Come on, load. Okay, here we go. Judge, I would object for the same reason. This testimony of this witness has to do with the definition of SMU, SM1 under DOC standards. She doesn't have any authority to, at least not that we've heard, change that determination. She's working within the protocols of DOC, and she doesn't appear to be part of the lawsuit. So, if hang on now. Doesn't appear to be part of that lawsuit. So if they have an issue with DOC not following protocols, I don't think this is the forum to be handling that in. This is about whether he was being coerced by his environment. The designation of SMI or not, doesn't have anything to do with whether he was coerced into making involuntary statements. And we're talking about environmental coercion. I understand, but there still has to be, in our perspective, the state's perspective, some act by people directly related to inducing him to make confessions. And we feel like that is outside of this issue, especially for this witness.
Go ahead.
May I ask some foundational questions of the witness?
Sure.
Ma'am, you were previously sworn. You understand that?
Yes.
Okay. Are you familiar with the DMS 4?
I am. It's not the current DSM, though.
I'm sorry?
The current DSM is the DSM 5 TR.
Okay, but I'm asking, are you familiar with the DSM 4?
For the most part.
Okay, and is that basically the Bible when it comes to medical diagnoses, psychiatric diagnoses,
Psychiatric.
those kinds of things?
Mm-hmm.
Are you shaking your head yes?
Yes.
Okay, and are you familiar with specifically with the settlement between IPAS and the DOC that I referenced earlier?
So I think we talked about this last time, and when I verified with one of my peers, they did say major depression did not fall under that umbrella
Okay.
at the present, so there must have been an update since then.
The question is, are you familiar with that settlement and the language that was included
Yeah.
in that settlement regarding serious mental illness?
Yes.
Okay. And is it accurate to say that that settlement statement defined serious mental illness and that definition was then adopted by the DOC
Yes.
during the course of your employment with the DOC?
Yes.
Okay. I do think she has a foundation. I mean, that settlement is referenced. I'm going to show you in the DOC policy. It's actually referenced in the policy. May I ask an omitted question of the witness?
Sure.
Ma'am, if I may hand you what's identified as Healthcare Services Directive Annual Policy and Procedures, looks like Police Policy 4.03A. Do you see that?
Yes.
I showed you this before, right? When I took your deposition.
Yes.
And is this the policy? This one's dated April 1st of 2022. Do you see that?
I see that.
And is this consistent with the policy that exists today that dictates how you treat offenders as a whole from a mental health standpoint?
It should be.
Okay, directing your attention to page 2, which is under definitions, section 2, page 2, section H. Do you see that?
I see it.
Is it accurate to say that the sections titled IPAS settlement,
Yes.
and then it references that there was a settlement between between IPAS and the DOC that relates to the classification of seriously mentally ill inmates and the 30-day threshold?
Yes.
So it's specifically noted in your guidelines.
Yes.
That's the basis upon which I renew my request for admission.
Judge, may I ask a question of the witness to clarify?
Yes.
Dr. Walla, how are you? This is all being geared towards whether Mr. Allen was or was not designated as SMI. Would you agree?
Yes.
Okay. And you said in prior testimony today that in your deposition that he did not meet the definition under DOC with regard to placement or transfer.
Right.
Okay. This hasn't been asked of you yet, but he was diagnosed as brief psychotic disorder with related stressors, correct?
Yes.
And that is a diagnosis that, in and of itself, requires that the brief psychosis is less than 30 days, correct?
Yes.
Does that not have an impact on the definition of SMI?
So, in regards to the brief psychotic disorder, it would qualify as SMI.
But there was a concern about the 30 days and when you began your analysis of that particular conclusion, is it not?
Can you be more specific?
Sure, I'd be happy to. His symptoms had to exist for a certain length of time.
Right.
Before his diagnosis could or would have an impact on changes in his placement.
Technically, a diagnosis alone, we have individuals who are SMI in restrictive housing for different reasons beyond the 30-day mark. This would be a new diagnosis for him, and we would at that point determine whether we'd want to transfer. However, given the unique circumstances of the case, in our meetings that I am not allowed to talk about, it was determined that he was going to stay where he was. So the way that I was told, he did not fall under the guidelines because he was not at IDOC incarcerated individual. He was a safekeeper.
I have one more question to clarify that, Judge.
Okay.
So his designation as safekeeper was a priority because his safety was the reason he was there.
Right.
Okay. And his psychosis that we just discussed, the brief psychotic disorder and related stressors, was successfully treated where he was. Would you agree?
Yes.
And in fact, in the deposition, Mr. Rosie asked you if you had the opinion that he needed to be somewhere else to get proper treatment. I believe your answer was, I'm quoting, no, we took care of him right where he was, end quote.
Yes.
Thank you.
May I question the witness?
Are we still on trying to get in T and U?
Yeah, I was trying to not
Okay.
object, or I'm sorry, I'm losing my train of thought. I was trying not to interfere with her because you've given me some latitude, but I feel like now we're kind of,
Well, we've kind of gotten way far afield here. I mean, you have renewed your request for the court to admit T and U.
yeah, because of that admissibility motion that I had not thought about when we were sitting here earlier. We talked about yesterday how we kind of all thought it was, part of this larger issue, and that we were just going to deal with it all at once.
Yes.
And so that's why I'm asking to renew.
Okay.
Then,
Then you are renewing it for the purposes of the state's motion for admissibility.
yeah, I think it's relevant within the confines of that motion.
Ms. Diener?
Judge, the motion relies on the statute specifically that indicate a psychologist has an obligation under confidentiality with the specific exception applied to this case about statements relating to the facts and circumstances of a homicide. I have not heard, and maybe I missed it, have a person's designation as SMI has anything to do with that exception.
Okay. I will show T and U have been admitted for purposes of your offer to prove. I'll sustain the objection to T and U coming in as evidence under the admissibility motion that the state has filed, but will maintain those documents under your offer to prove.
Very good. Thank you.
You may proceed with the witness.
Thank you. Miss, or Dr. Walla, I should say, let's talk about your personal knowledge of this case, okay?
Okay.
Is it accurate to say that you followed this case on social media basically from the inception of the case, pretty close to that time?
Pretty close.
And when I say that, back to 2017,
Probably not that far.
okay, near that time,
Maybe a couple years after.
okay, and is it accurate to say that your following this case involved you listening to different podcasts and things of that nature that specifically covered this investigation?
Yes.
And that those podcasts were all on kind of online social media based sites, right?
Yes.
Is it also accurate that you did follow this case on Facebook and certain forums, I guess, as for lack of a better phrase, on Facebook?
Yes.
And so that you had a significant amount of knowledge about the circumstances surrounding the investigation before you were engaged in services with Mr. Allen?
Yes.
And is it accurate to say that at one point, a year or so before Mr. Allen was arrested, that you actually visited the Monon High Bridge yourself out of your own personal curiosities
Yes.
regarding this case?
Yes.
And is it accurate to say that you told me that you actually went out of your way to do that on a trip from Indianapolis back to the Chicago area?
Yes.
You basically took a detour here into the Delphi area.
It was on the way, but yes.
And you did that with your boyfriend in tow, so to speak.
Yes.
You were together, right?
Yes.
This was on personal time.
Yes.
Is it accurate that you followed this case more closely after Keegan Klein, who was a suspect, was arrested?
Yes.
And that was before Mr. Allen was arrested, correct?
Correct.
And that's because you were interested in the Keegan Klein angle to the investigation,
Yes.
right? All of this was personal.
Yes.
And is it accurate to say that you followed the case even more closely after Mr. Allen was arrested?
Yes.
And did you tell me in the deposition that you actually made it a habit and it was a routine for you to listen to coverage, podcasts, if you will, to and from your commute to work?
Yes.
How long is your commute?
hour and a half.
One way?
Yes.
Yes or no?
Yes.
You did that several times a week, right?
Yes.
And this was a big part of your life from a personal entertainment standpoint.
Yes.
Did you acknowledge to me that you sought out information regarding the Keaton-Klein aspect of this case while you were at work?
Yes.
And that you sought that information out on the case management system or access to those files that you have at work?
Yes.
And tell me how that happened. I thought you gave me a name for that system.
Insight.
Okay, so I was right earlier, so it was Insight. You have access to a system called Insight,
Yes.
okay? Is that like INCITE?
Yes.
All right. And does that system offer you access to specific information regarding incarcerated individuals around the state?
Indiana.
Okay, what else can you get there that's private?
The pre-sentence investigations would be private, I believe.
Okay.
And then any other court document.
So a pre-sentence investigation, is it accurate? Is a document that basically summarizes the life history of an offender, sometimes from birth all the way to the point when they're incarcerated.
Yes.
Very private, detailed information.
Yes.
And is it accurate that you actually access that information through the DOC case management system regarding Keaton-Klein
I did.
because of your interest in the Rick Allen case, the Delphi case?
Yes.
And you did that for personal reasons. You told me that, didn't you?
Yes.
It's for entertainment reasons, right?
Yes.
It's not for professional reasons, right?
Right. Right.
And do you acknowledge that this is inconsistent with the policies under which you work?
It might be.
You're not supposed to use that information for entertainment reasons, are you?
I'd say no.
Have you been disciplined for that?
No.
Has anybody ever talked to you about, hey, that's a really bad idea?
No.
Okay. And do you acknowledge that at one point that you publicly commented on Mr. Allen's case in a social media forum?
Yes.
And that comment came at a time after he was arrested?
I believe we determined the timeline to have been a few months back this year.
Okay. So after October of 2022.
Well, yeah.
And after you were treating him, or actually, it was during your time treating him as a patient.
He had already moved on to the next facility.
Down at Wabash Valley?
Mm-hmm.
Yes.
Yes.
The place where you visited him after he moved there, right?
I did.
May I approach, Judge?
Yes, you may.
What's the next? I'm sorry. What's the...
W. Yeah, you're up to W.
I'm going to hand you what's been marked as Defendant's W. Do you recognize this document?
Yes.
And just tell the judge what it is.
Someone had posted about a podcast recommendations, and I provided the ones that I listened to.
Okay. So it's a screenshot of a social media post. Is that a fair way to describe it?
Yes.
Okay. And this is generated by the text at the bottom here is a post by you. Is that right?
Yes.
Okay. And it's under your
Yes.
real name, Monica Walla. There's no pseudonym here.
No.
No online handle or anything, right?
Right.
Okay. Move to admit W.
Any objection? Ms.
No
Diener?
objection.
All right, without objection, W is admitted.
And do you acknowledge that in that post that you rendered a public opinion about your feelings about different podcasts involved in this case?
I suppose there's some opinions, yes.
Okay. Well, sure. You talked about how one of the authors or one of those podcasts or creators about how his calm tone was unnerving, right?
Right.
And do you acknowledge that you actually at one point talked to Rick Allen about the environment and the tone about what was being communicated on social media about his case?
Right. I mentioned that he had supporters.
He was talking to you about people wanting to kill him and things like that, right?
Yes.
And you shared with him, hey, I've been following this stuff and this is what I'm seeing.
Yes.
Now, ma'am, earlier I was going to offer you defendants W. These are, this one's W. Oh, yeah. I must have marked this right before the break. If Jody will give me a new sticker,
I think you're at X now.
let me hand you what's been marked as Exhibit X, entitled Ethical Principles of Psychologists and the Code of Conduct. See that?
I do.
Those look, take a quick peek at them before I ask you questions, just to make sure that it is what it says it is on the front. You recognize those ethical principles?
I do.
Getting to the bottom of this, are these your code? Is this your code of conduct?
Yes.
Administered by the American Psychological Association?
Yes.
One of the problems when I had made copies over the break, they're not colors, so I don't have the highlights that I tried to use to create for the court for convenience, so bear with me. Judge, I move to admit Exhibit X.
No objection.
Okay, without objection, X is admitted.
I'm going to hand the court a copy in case you want to try to.
Okay,
They're not highlighted, but other than that,
that's all right.
they don't have a color copier here yet, so just quickly let me direct your attention. May I proceed, Judge?
Yes, go ahead.
Let me direct your attention to page 3, section Principle B. Do you see Principle B
I do.
on the right side here near the bottom?
I do.
Okay. It says psychologists have full professional standards of conduct, clarify their professional roles and obligations, accept appropriate responsibility for their behavior, and seek to manage conflicts of interest that could lead to exploitation or harm. Do you see that? It's about the 4th line down.
I see it.
Okay, and do you acknowledge that you participating in the online social media activity in this case for personal reasons while you're treating a client it's reasonable to believe that that's a violation of that policy?
I disagree.
Okay, let me direct your attention to Principle E on page 4. Do you mind taking a look at that, please?
I'm sorry, page what?
4.
Thank you.
Do I need to talk a little louder?
No, I just didn't hear it.
All right, Principle E, titled Respect for People's Rights and Dignity. Do you see that?
Yes.
First line says, psychologists respect the dignity and worth of all people and the rights of individuals to privacy, confidentiality, and self-determination, right?
Yes.
Do you agree that by posting anything online about your opinions towards this case runs afoul of Mr. Allen's privacy rights?
I feel like that's a gray area.
Do you disagree or agree with it? Close call, right?
I didn't talk about him specifically.
Okay, so you don't think it's a violation?
I'm going to go with it's not.
Okay, that's what you're going with?
Yes.
All right, page 6, conflict of interest. Read that, please.
Mm-hmm.
Are you there?
Mm-hmm.
A psychologist will refrain from taking on a professional role when personal, scientific, professional, legal, financial, or other interests or relationships could reasonably be expected to, number 1, impair their objectivity, competence, or effectiveness in performing their functions as a psychologist, or 2, expose the person or organization with whom the professional relationship exists to harm or exploitation. Do you understand that
I do.
provision? Do you agree with me that this provision takes into consideration the conflict between being personally involved with a client and legal situations?
You'd have to explain that further.
I will do that. Thank you. I withdraw the question. Do you acknowledge that this conflict of interest statement references the existence of legal circumstances associated with clients.
There's legal circumstances, yes.
And we have this in this case because we're sitting in a courtroom, right?
Yes.
And do you agree that by participating in Mr. Allen's case on online sites, that it could reasonably impair your objectivity to this case in his situation?
I'd have to disagree with that.
Do you recall me asking you about the information that you obtained online, the quality of it?
Yes.
Do you recall, is it accurate to say that you told me that the quality of it's not good?
Right.
It can be poor, right?
I did say that.
So you're consuming all of this information about his case, some of which is poor, right?
Right.
And yet still trying to treat him in a professional capacity.
But I'm not using the stuff that I read about in my professional work with him.
You were able to compartmentalize this thing entirely?
Yes.
There's nothing that you're hearing on a personal level that has any impact whatsoever in the way you feel about his circumstances?
We work with individuals who are already convicted of these types of crimes, and you don't treat them based on those crimes.
Okay. Are you treating anyone else that you're following on social media posts,
There haven't been any
podcasts, anything like that?
major stories in the area.
And
No, the answer is no.
directing your attention to page 7, privacy and confidentiality, bullet point 01, maintaining confidentiality. Do you see that? It says psychologists have the primary obligation and take reasonable precautions to protect confidential information obtained through or stored in any medium. You see that?
I do.
Okay. You'd acknowledge that you obtained confidential information from him in the form of your bench notes or your session notes that you were taking.
Yes.
And do you acknowledge that you destroyed those notes?
Yes.
And do you acknowledge that that is in violation of Rule 4.01?
I'm not sure if that's accurate.
Is that unreasonable for me to take that position?
That's what all of us do at the prison. We don't leave our notes just lying around.
Okay, so if everybody does it, it's okay?
Well, I'm not saying that, but what am I supposed to do with all those papers?
Okay, fair enough. Give me a second.
All right.
Section 4.02, it's titled Discussing the Limits of Confidentiality. Do you see that?
Yes.
Basically, it says that you're supposed to have a discussion with your patient about the limits of your confidentiality, right?
Right.
Obtain informed consent would be another way of putting that.
Right.
You didn't do that with Rick Allen, did you?
I can't say 100% because she still had the form active from RDC, which is still the same form that we'd be using in our work together.
You didn't talk to him when he was at RDC, did you?
No,
Somebody else did.
that's right.
And it wasn't a psychologist, was it?
It was.
Okay, who was it?
Dr. Premu.
And did you talk to Dr. Premu about what she talked to Rick Allen about?
I did not.
So you don't know what she said to him?
The form was the evidence for that.
You don't know what she said to him?
I don't know what she said to him.
Did I move to admit? Yes, I did. I gave you the
Yes, you did.
copy of the...
Yeah, I've got it.
So here's the one with the highlights.
Oh, okay.
I was just trying to help you.
Do you want this one back?
Ma'am, you also acknowledge that you have other standards that dictate through the APA the record-keeping procedures that you are to abide by.
Okay.
Is that right? I'll show them to you. Let me hand you what's been marked as defendant's Y. Take a look at that. Just take a quick look. Are those the record-keeping guidelines that have been issued by the American Psychological Association?
It appears they are.
I'm getting the impression you're not familiar with these guidelines. Are you familiar with these guidelines?
I guess in terms of, the destroyed notes. I don't know. It's just the way that we practice. I prefer to keep personal notebooks full of notes about my sessions. I put all the important information in the medical records. So,
Are you familiar with these guidelines?
not as much as I probably should be.
You acknowledge that these would be guidelines that would apply in your course of work?
Probably.
Move to admit why.
Can I see a copy? Oh, it's right here. I apologize. Let's see here. Bunch of stuff on records. No objection.
All right, without objection, Y is admitted.
I'm going to do the same thing on this. I'll give you this just so you can follow along.
Okay.
Oh, wait a minute. It does have highlights.
Well, the one you gave me didn't, but I highlighted it and gave it back to you.
Oh, I thought I did it.
That's okay, but this one has highlights. Okay, I'll take the sticker off. Thank you.
Okay. Let me direct your attention to guideline number 2, content of records. A psychologist strives to maintain accurate, current, and pertinent records of professional services as appropriate to the circumstances and may be required by the psychologist's jurisdiction. Records including information such as the nature, delivery, progress, and results of psychological services and related fees. Do you see that?
I do.
Under guideline number 2, this is, by the way, on page 995. I guess down here at the bottom right, consideration regarding the level of detail of the record. Do you see that?
I do.
Do you acknowledge that here at the bottom it basically says that there may be advantages to keeping minimal records, but in circumstances, give me a second, in circumstances regarding unintended disclosure, that there may be reasons to keep more highly detailed reports, right?
Yes.
So one of those things might be like litigation, right?
Yeah.
Potential for litigation, which is always, would you agree, possible in your setting because of the nature of it?
Yes.
So the best practice based on this guideline would be to maintain those records, correct?
Yes.
Directing your attention to further down in section guideline number 2, specifically page 996, on the left side here, there's actually a paragraph called alteration or destruction of records. Do you see that?
I do.
And it says, fourth line down, in the context of litigation, additional removal of information from a record that has been subpoenaed or requested by a court order may create liability for the psychologist. In other words, if somebody's seeking records, you don't want to go destroying them, right?
Right.
And it talks about you may need to seek consultation regarding law, state and federal law, before changing the record. In other words, before destroying anything, correct?
Okay.
Well, is that what it says?
That's what it says.
Okay. So this actually, the best practice here is that you should maintain records in cases where litigation may be a possibility. Agree with that?
Maybe.
You disagree?
It says that, but just the way we practice. No one does that. So I need to open a whole conversation about that with others now.
Is it possible that everyone's doing wrong?
Possible.
Okay. Guideline 4, I'm not going to get into this one too deep, but if you want to just take a quick look, the question, simple question, does that suggest some informed consent from the client? Basically, you should let the client know that what you're doing with the records.
Judge, while she's reading that, I'd like to object to this line of questioning. It appears that defense is trying to discredit Dr. Waller with the way that she does her business at DOC. But the motion is about suppressing statements of Mr. Allen. And if they were coerced by his environment, I'm not sure how her adherence to these record-keeping guidelines that she's being handed to review on the spot and give her opinion as to whether they are so important or not, and whether she agrees with Mr. Rosie as to whether she's following them in any way, that she should be has any bearing on number one, the voluntariness of Mr. Allen's statements and whether his constitutional rights were violated in obtaining these statements, and whether the exception to confidentiality is impacted by that line of questioning. The statute says all records are confidential except they can testify about statements related to homicide, facts or immediate circumstances, and circumstances under which privileged communications is abrogated under the laws of Indiana. We are here with Dr. Waller because that's put his mental health at issue. So it wasn't her job to tell Mr. Allen, hey, there's a statute out there that has exceptions for communication between you and I. Because the baseline is everything's confidential except these two things. We didn't know about the mental health records until we were allowed to have them from the court because they put his mental health at issue. So her adherence to policy about whether she takes her notes and memorializes them into an electronic system because she feels like it's more secure, I still don't know how that impacts either one of these arguments.
Mr. Rosie?
Thank you, Judge. So, again, you go back to the very beginning of this case when the Honorable Diener, Judge Diener, signed a court order that said Rick Allen is going to the DOC and he's going to be subject to their jurisdiction, which means all their rules and regulations, it's a due process issue. Number two, he gets there and he's assigned a psychologist, as well as others, to his care and custody. And there are rules that dictate how they process him, and how they treat him, and how they treat him both medically and psychiatrically, and from a custodial standpoint. It's our contention that they didn't follow those rules. And so, again, this goes to a 14th Amendment argument, article and section, whatever the Indiana section is. I'm sorry, I lost all the numbers in my head. I cited them earlier. Section 12, I think, is the due process clause. So it's relevant for those reasons. The second reason why it's relevant is, again, we get back to the state's request for admissibility. They're basically asking you to say, you know what, Judge, we want to take advantage of this statute that's been created so that we can extract information from a psychologist about a doctor-patient privilege based on an exception, when in fact, the best evidence of that was communicated between these two people, Rick Allen and his psychologist, has been destroyed. And I think those two things are contradictory, and I think they contrast each other, and I'm asking the court to find that it's relevant for that reason.
Marginally relevant?
I'm sorry?
It's marginally relevant.
Thank you.
Overruled.
Unbelievable.
Ma'am, do you agree that there's other, well, I'll show this to you because you said you weren't really familiar with them. There's other guidelines here that pertain to, I'll try to help you out here.
Okay.
Guidelines 4 regarding the disclosure of record-keeping procedures generally, right?
Uh-huh.
Yes or no?
Yes.
And Guideline 6, security as it relates to steps to protect records. Do you see that?
I see it.
Okay, and then Guideline 7 pertains to the retention of records for psychologists and striving to maintain compliance with applicable laws and regulations, right?
Yes.
I'm not going to go through every one in the exhibit. You see those in the guidelines, correct?
Yes.
And I think I moved to admit that.
You gave, yeah, you did. It's admitted.
And you have your copy?
Yes.
Okay, this is why.
Okay.
Let me hand you what's been marked as Z for purposes of identification. That looked like 2. Defendant's Exhibit Z, titled APA Guidelines for the Optimal Use of Social Media in the Professional Psychological Practice. You see that, at least on the cover sheet?
Yes.
You see that it's issued by the American Psychological Association?
Yes.
Are you familiar with these guidelines?
To an extent.
Okay, so these guidelines regulate your profession as it relates to your activities on social media in the course of your therapeutic practice, right?
Yes.
Sorry, I'm talking over you. Do you agree with that?
Yes.
Very good, thank you. I move to admit Z.
Any objection?
No objection.
All right, without objection, Z is admitted.
Let me direct your attention to guideline 2.1, page 10. Bottom left corner is the page number. See that?
Yes.
I'm going to give the court an opportunity to get there. Guideline 2.1, psychologists are mindful of the public nature of social media and that their privacy and confidentiality are not protected nor expected on social media. See that?
Yes.
Do you agree that your sharing of information about your opinions in this case on social media was improper?
I do.
If you had to do it over again, you wouldn't do it over again, right?
I wouldn't.
And do you agree that, and I can go through every one of these guidelines, but basically that runs afoul of the best practices referenced in the guidelines, right?
Yes.
Ma'am, earlier I introduced to the court, what am I marking now? I'm at Z, so AA?
You're starting at AA.
AA?
Uh-huh.
Handing you what's been marked as defendants AA. This is the DOC directive on, or healthcare services directive number 4.03A. I showed you this earlier, right?
Yes.
And you acknowledge that this was dated April 1st of 2022?
Yes.
And you acknowledge that this directive basically, again, mentions the IPAS settlement and sets the tone for, or the guidelines for, how you treat offenders in restricted housing specifically, right? Let me just make sure give me 1 second here. Directing your attention to page 15 of the guideline, would you take a look at that? The page numbers at the,
Oh,
up here in the top right in the box, do you see that?
yes.
Page 15 of the guideline actually recognizes that there are special mental health services available through the DOC. Is that right?
That's right.
And if you turn the page to 16, it starts to identify the different facilities where the DOC provides special mental health services, correct?
Yes.
Okay, and the first one of those is actually Newcastle, right?
Yes.
The second one, Pendleton.
Yes.
The third one, Wabash Valley, where Rick is now, right?
The special needs unit.
And the fourth one is the Indiana Women's Prison.
Yes.
Westville is not even on the list, is it?
No.
Move to admit AA.
Any objection?
Let me see that. No objection.
All right, with objection, which is it should be without objection. Double A is admitted.
Just a minute, Your Honor. Let me get organized here. So you agree with me that this 30-day threshold that we've talked about is really in place to ensure that someone with a mental health condition, a serious mental health condition, is not further harmed. That's the reason why there's a policy, right?
Yes.
Is it accurate to say that the only reason why you've taken the position today that the DOC is not subject to that in Mr. Allen's case is because he was designated as a safekeeper?
That is what I was told.
And you didn't even make that decision, right?
No.
If you were treating him from a clinical standpoint, from a mental health standpoint, you would be acknowledging that solitary confinement circumstances and how it could be detrimental to him, right?
Yes.
But you couldn't make those choices. Is that what you're saying?
Couldn't.
You wish you could, right?
Yes.
Or you would have done something different, wouldn't you?
Yes. Possibly.
You would have helped him, got him out of there.
Possibly.
In fact, you said it's reasonable to believe, you told me in the deposition, reasonable to believe that his situation with psychosis was caused by confinement, didn't you?
Stressors pertaining to confinement, yes.
For 7 months, he was in prison when all of those stuff occurred, wasn't he?
Yes.
I have nothing further.
Miss Diener.
We want to go off the record for a minute so I can get a glass of water. Did y'all want to
I
talk
would
about
love to
these
because I'd like to
guidelines
get
at all, or just keep
We're
going?
off the. Yep. No, we're off the record. We will be right back. I need to grab a soda pop. My Dr. Pepper is on E, and Walla Walla says yes too often. I need a drink.
Two seconds.
So if anybody hasn't noticed, I've taken over Walla Walla. Ange had to go, so I'm gonna finish up as her. So if I miss a court something or other, I apologize. I'll try to do both.
Okay, I'm good to go.
So we have
Good,
53. We have 53 pages left.
That's
okay,
good.
want to just keep going, or did y'all have any comments about the
I don't have any
guidelines
comments
you wanted
yet.
to cover while we were off the record?
I don't have anything. Do you have anything, Sleuthy?
No, not really. Other than my annoyance that she doesn't seem to really know anything about her guidelines.
She doesn't know what she does. She
Yeah,
just
some
does whatever.
surprising answers.
Yeah, very.
Yeah, not as much as I should be, and
And that basically nobody
was,
follows those. Like,
kind of
really, ma'am?
Actually, give me 1 second. I'm going to run to the restroom. I will be right back.
Okay.
there. There was a lot of talk about it at the time, even before this hearing, which was in end of July and early August, the 3 days. And my recollection is that people were talking about, you probably among them, Nicole and Teresa, that this had come out in social media that there's a Walla on one of these social media groups. You think that could be her? And like, no one's that dumb, And then,
Yeah.
lo and behold, I don't know if it got confirmed prior to this hearing, but it was certainly confirmed. But there was a lot of talk at the time. People pulled up the various guidelines, and professionals. I don't know if there was any PhD psychologists, but people like Ange and others. And then there was I pulled them up and was trying to research, and it varies state by state. Some it's kind of more like guidelines, and depending on the state, they'd say what was done in this case would be absolute violation, and you would be subjected to some sort of discipline. And other places, because of the wording of the guidelines, which is typical of ethics rules, they're written by committees, the wording of the guidelines leaves it up in large part to the professional discretion of the professional. So they're policing themselves. Now, there was an earlier part of this testimony that caught my eye where she was digging into a system on that other person that was prosecuted. Fine. That would be a crime in Texas, accessing confidential information. Like NCIC, it applies to everybody, but Texas has its version of NCIC, which is the National Criminal Records Index. It's called TCIC, surprisingly enough. But going in there unrelated to your work, just because you're a police officer and have access, but going in on something that you're not investigating, that's a crime in Texas. And
well, similarly,
they kind of
for me,
yeah.
like I have full access to Epic throughout the entire hospital system. But if I go into a patient's chart that I'm not treating, that's an enormous problem. And I just don't do it. You don't do it. That's why you log in with your name, so you can be held accountable if you're into something you shouldn't be. That's basically what she did. The equivalent of what she did was click on an entirely unrelated patient that she's not treating. You can't even do it for your family. Like if my mom is like, hey, can you look in my chart and see my blah, blah, blah? Like I cannot do that.
Not without a release. And then probably hospital policy is even with the release, it's got to be in connection with your employment at that hospital, that facility. And if
Right.
it's not for that, even with a release, it's probably a policy violation.
Mar, it's like
Um,
really up. I mean, it's
yeah.
kind of hard to tell if anything happened to her because there was some mention about her like not being employed with them anymore, and there was some kind of notice or something, but they were very wishy-washy about it. I don't think we've really gotten to it yet, or they only briefly touched on it. I hate her too.
Well, they asked, anybody talk, you've been disciplined for this? Anybody even say, hey, it's probably not a good idea? No. And then we're kind of used to that with Proctor and Higgins and others in Reed, that if you got your star witnesses, we're going to go with, hey, immature, not the best idea, but it didn't. You saw she got in, she was prepped. It didn't impact my treatment of him.
I don't believe that.
Yeah. So
I don't know how there's any way to prove that one way or the other. So I guess that's the whole. It's up for interpretation, not.
Right.
Yeah. So you're back, T. I don't know if you had anything to add.
Nope, I'm ready.
Okay. Whenever you go back,
We'll go
on the record.
All right, we are back on the record.
May I proceed, Your Honor?
Yes.
Dr. Waller, these policies that you most recently identified and acknowledged, those have effective dates of April 22nd. So these policies would have been in place when Richard Allen was in Westville, correct?
2022, yes.
So to the extent that they comply with whatever came out of the lawsuit, the adjustments had already been made before he was there.
Yes.
With regard to your notes and your documenting, I believe in the deposition you said you would take notes, and in fact, if there was a particular note that you made that was a quotation, it appeared in your behavioral health suicide observation record in quotation marks. Is that correct?
Yes.
Is there any reason to think that you would have had something in a written note that you felt important enough to write down that you did not then enter that into the record keeping system?
No.
So by destroying your notes was destroying a duplicate.
Yes.
And you said that you felt like it was not a good idea in your testimony to have it floating around. Is that correct?
Yes.
Outstanding. So by putting it into the system, what do we call that system?
The electronic medical system or a record.
Right. By putting it in there, it is more protected than a piece of paper that you might put in a locked file cabinet in your office. Is that correct?
Correct.
Do you have a locked file cabinet in your office?
No.
You're expected to use the electronic case system for medical records, correct?
Yes.
Okay. And did you prepare your behavioral health suicide observation records from your daily visits with Mr. Allen the same day that you visited with him?
Typically, yes.
On occasion, there might be an addendum you would do on a different day. Is that correct?
Yes.
Okay. You've made reference to a consent for treatment and limits for confidentiality in your testimony, and the belief that Dr. Primo is that how you say it? Primo?
Yes.
That's spelled Primeau. Primo.
Yes.
At RDC would have gone through those
Yes.
with Mr. Allen. And then what would have been the limitations on you going through them with him again?
I may have done it. I just don't remember.
Is there any reason there would be a document printed with your name and date, but no signature from Mr. Allen? Would he do an electronic signature, or how would you do that?
Can I see it?
May I approach the witness, Judge?
You may.
Thank you, Your Honor. I'll show you what's been marked as Exhibit 9. It's a 2-page exhibit. Can you identify those?
So this is the one that was signed at RDC with Dr. Primo. Okay, so this one, I did go over it with him. This would be something that you'd find in his paper chart. And this is the one they have us generate in our system just to kind of place the date of when we would have collected it. So there really should be another actual one with my signature somewhere.
But for clarification, the front page is one with Dr. Primo at RDC,
Yes.
and it's signed.
Yes, and then this one was on 11/8 by me, so that's the date I would have talked to him about it and likely put some note in.
His file.
Possibly another intake.
So seeing this document caused you to believe that you went through it with him on the 8th of November.
Yes.
Move to admit Exhibit 9. Not hearing an objection, Your Honor. I say you admit that sucker.
Do it real quick when there's no attorney here.
No objection.
All right. Thank you, Mr. Rosie. All right, without objection, 9 is admitted.
I'd like to show you what's marked as State's Exhibit 10. It's several pages. It's one of your reports from November 10. I'll give you a chance to look at that. You done reading that?
Yes.
Okay, on 11/10, did you talk with Mr. Allen about disclosing facts about his case? In the middle of the paragraph.
Yeah, I see it.
Quote, this writer recommends he not speak about his case to anyone except his attorney. Made it clear it was appropriate to accept help with coping with the mental health symptoms he is experiencing as a result of his circumstances. End quote, correct?
Yes.
So that's your role, correct? To help him with his mental health
Yes.
and his circumstances. State would move to admit Exhibit 10, Your Honor.
Any objection?
Not hearing one. Put it in, Judge.
All right, without objection, 10 is admitted.
So you don't need to know about the details of his case to offer him mental health services, correct?
No, correct.
So it would follow that you would not ask him about the circumstances of his crime, whether he committed it, if he did it, what the details were.
No.
Okay, now, there were lots of questions early on about the conditions of his confinement and the small space, and he had to move around in. You're familiar with it, correct?
Yes.
And is it correct that early on, Mr. Allen made the best of things and he would exercise in his room? He was reading. He was walking around his room for exercise, correct?
Yes.
Taking care of his daily, I'm not sure what ADLs stand for.
Activities of daily living. So just bathing, brushing your teeth, keeping yourself clean, eating.
Okay, well, that's why I didn't know that. I don't do most of those things. And those are things that you, as one of his providers, would watch to determine his needs, correct?
As much as I could.
Okay, well, there were daily most of the stay, correct?
Yes.
Except for weekends.
Right.
Did he also have someone either from mental health or from staff, custodial staff, that would meet or stop by and see him twice a day? It was on a restricted housing unit log.
Right. So it just depended on where he was at. If he was on suicide watch, obviously
he's already getting daily visits, so there wouldn't be extra visits on top of that. If he wasn't on suicide watch, then yes, someone would come and see him.
Every day?
At one point, it was every day anymore when he was completely off it, but at least weekly.
Okay, during the time from March to July.
It was more like December to beginning of April is when he he wasn't on suicide watch, so
Okay,
we didn't have all the extra stuff going on.
okay, so that was an extra added when you felt he needed it.
Yes.
Okay. There is a note from early on in his time at Westville, November 3rd, that indicates Dr. Primo gave the mental health order for constant suicide watch due to high profile nature. Is that what you're familiar with as far as his restrictions?
Right. So that's how he came to us. He was at RDC for one day, I believe. She provided those orders and he arrived with those orders.
So would constant watch account for all the supervision while he was being moved? Is that correct?
And it's constant suicide watch that we implemented.
Okay. And that was for his safety, right?
Yes.
And when he arrived at Westville, it appears that you also did a bit of an intake with him, asking him about his history, employment, education. Is that correct?
Yes, yes.
And what do you recall about Mr. Allen's background?
Married, has a daughter, worked at CVS, usually held managerial positions, made good financial decisions. He told me he owned his house and 2 cars.
Okay. And when he was initially on the unit, he did not, well, he always had a suicide companion. Is that correct?
He did.
Okay. And you said you had some problems or frustrations with the inmate companions. And what specifically did you have an issue with?
At what point in time?
Well, the inmate companions were only there for the first few months, correct?
No, they were there the whole time. So on our end for Suicide Watch, we used them for the first month, but even after that was discontinued, administrative staff kept them on to just be there.
Okay.
In terms of problems, as we previously mentioned, I think some of them were spreading information to their families.
We don't know what that information is, do we?
Not necessarily, no.
I mean,
I do know how much specific it could be, aside from this guy's here,
right. We certainly don't know if it was details about his case.
Right.
You don't have any reason to know that.
No.
We've heard testimony that suicide companions are instructed not to engage with Mr. Allen. Would you agree that that is expected?
It is.
And when it's changed to officers, do you see issues with officers that they would engage in? If so, what does that mean?
Well, that is outside of my control. We can't stand and watch them, all hours of the day and night. So
Did you ever see them engage?
not more than normal. I mean, sometimes they'd be delivering a tray of food or some, nothing out of the ordinary.
So when I say, did they engage, if they say, Mr. Allen, here's your food tray.
Right.
Is that engaging?
Well, it is.
Okay.
But
That's not a violation, is it?
no.
Okay. They need to come and get his tray.
Yes.
Okay. If they come for medication delivery, that's engaging, but it's not necessarily detrimental or against the rules, is it?
No.
And when you would arrive on the unit, would you review? It seems that you make reference to reviewing suicide companions.
Yes.
Let's see, notes to inform yourself about what he's doing.
Yes, about how he's doing. Yes.
Do you rely on that information to some extent?
To some extent.
Were you aware that suicide companions were documenting him making confessions, right?
Yes.
You would see those when you came in on the unit.
Yes.
And did you ever see a situation where an officer companion or inmate companion was engaging with Mr. Allen in an inappropriate way in order to solicit a statement?
I didn't witness that.
You talked about, in response to questions, receiving an inquiry about someone associated with ISP wanting to talk to Mr. Allen. Do you remember that?
Yes.
Was it your understanding they wanted to talk to Mr. Allen or to you?
I think to me.
And so you asked Mr. Allen if it was okay for you to talk to them if they had questions about him, correct?
Right.
Okay, and you didn't know where this person was from. They didn't contact you directly, did they?
No.
And so where did you get your information from?
I honestly don't have too much memory of that. Someone must have passed them along to me, and I thought it was strange, and I asked what I should do. And I'm assuming they just said to go ask him if he wants me to talk to this person.
Okay.
But I think when he said no, I agreed and that I shouldn't.
And it was actually someone by the last name of Goldberg, you said, or Goldenberg, and your document indicates that it's a forensic psychologist, correct?
Yes.
Do you recall that?
Yes.
So it could have just been to have a conversation on a professional level,
And obviously still inappropriate, so.
and you didn't do it.
Right.
And you were asked about the out of cell cubicle where sessions occur.
Yes.
It was referred to as a cage. Is that what you call it?
Yes.
Okay. Is that what inmates call it?
I don't know.
Okay.
Some of them might.
It is, and you said it was the same as there is in Wabash Valley Correctional Unit.
It's not the same.
Oh, I thought you said it was the same. What's different?
This is basically a room. It's a triangular shaped, and as opposed to having two individuals sitting on stools real close together at a small table, they put a gate kind of separating the space into two. So one person will be behind the gate and then we'll be out here.
And which one has the gate?
The incarcerated individual goes inside the gate and they lock them in there.
But which facility has the gate? Westville or?
Westville does.
Okay.
The one at Wabash was it was just this structure that was just standing, and I didn't use that one when I was there with him, but I've never seen one like that.
Okay, it was a freestanding
Yeah.
room. And did it provide you privacy to talk with Mr. Allen?
The
At the facility at Westville when you were
Yes.
in treat psychology.
Yes.
I just want to touch on this, even though it seems out of context, but for the purpose of the statute we're addressing today, are you a certified psychologist with the state of Indiana?
Licensed.
Licensed.
Yes.
Before the beginning of April, when Dr. Allen got his legal documents, would you consider him to have been stable at that point?
Relatively stable at his baseline, at least. I mean, obviously he was depressed and unhappy about being there, but not much beyond that.
He was eating.
Yes.
He was taking his meds.
Yes.
He was taking care of himself.
Yes.
He was exercising.
Yes.
He was reading.
Yes.
Using rec and shower.
There was always discrepancies because he refused those. So I couldn't tell you how many times, but he would go out at times.
When you saw him, he was clean?
Yeah.
Okay. Was he able to carry on a conversation?
Yes.
And so his baseline is depressed and anxious. Would you agree?
I'd say so.
Well, you saw him very, very frequently for a whole year. So I guess I'd defer to you. Is that his baseline?
Yes.
On April 3rd and 4th, 23, he received his legal documents. Do you recall that?
Yes.
And would you say it was a large volume of documents?
Yeah, that's what I was told.
Oh, you did not see them?
I didn't.
Okay. I'm not saying you did see the content of them. Did you?
I didn't see anything.
Okay. Oftentimes you went to his door to speak with him to see if he would want to come out for a session.
Yes.
Would you use that opportunity to observe whether he was taking care of his daily living?
Yes.
And on the 4th of April, his circumstances changed significantly. Is that correct?
That's correct.
And you made notes about your observations with regard to what was different about him and about recent events. Do you recall that?
Yes.
And what do you recall about it?
My understanding is that he was presenting bizarrely. His thought process was disorganized. His speech was disorganized. There was a change in his presentation.
Bizarrely. Let me write that down. Did you also note that he had just 2 visits from his counsel, his attorneys? So you felt that contributed to what was happening with him, at least potentially?
I think we believe that at the site that it may have caused it because it was a major event that happened just prior to the change.
So the bizarre behavior resulted in him going back on suicide constant watch. Is that correct?
Yes.
Your report from that day also indicates that on the same date, it started confessing to other staff.
Yes.
And you documented those things in your notes as well?
The quotes were from the companions, the logs.
I'll show you Exhibit 11, your notes here about someone.
Yes.
State would move to admit Exhibit 11.
Any objection?
No, ma'am.
Thank you, counsel.
All right, without objection, 11 is admitted.
Prior to April 4, did Mr. Allen share with you that he had found God? I don't know when he started talking about, Did Mr. Allen also share with you that he had found God?
I don't know when he started talking about God, although at our initial intake, he said that he wasn't really religious, and then it did end up progressing into a strong belief in God, but I don't remember when it started.
I'd next show you what's marked as State Exhibit 12, your document from April 5. You have a chance to review it?
Yes.
Okay. On April 5th, did you have some quotations under patient complaint? And I guess for the court's knowledge, I'd like to talk about the nature of the report. The report always starts with a paragraph at the beginning about the last change in his status. Is that correct? The first paragraph references back to April 4.
Right, the reason for placement.
Okay, and then patient complaint is where you document the statements or conversations or clinical impressions that come from a particular date on the report. Is that correct?
Yes.
Okay, and this was an out of cell session, so there would have been confidentiality for Mr. Allen.
Yes.
And he makes 2 very specific statements about the facts and circumstances of the charges that are pending. Is that correct?
Yes.
How would you begin your sessions to engage Mr. Allen in conversation?
Yeah, I mean,
To be helpful.
it's pretty much just I kind of put it on him, like, so how are you doing? What's new? What's going on? And then just see where he takes it.
Okay, and if his behaviors were not acceptable, were not in his best interest, you might ask him about those as well.
Yes.
But was it ever your intention to say, hey, did you commit the crimes that you're charged with? Well, what happened? Well, what are the details?
No.
Okay. Did you avoid that on this particular day as well?
Yes.
One of the things that you also indicated on here was, I'll paragraph in the 5th paragraph of patient complaint that he shared with you that he took God into his heart on March 21st of 2023.
Yes.
So very recently.
Yes.
Does he relate his new interest in religion to his statements to you about committing the crime as if they are related for him?
I don't think so. Well, the very last line there.
Okay. So he makes reference to the crime, and then he ties that to his belief in God and what he wants to do with the Bible, does he not?
Yes.
Okay. Taking into consideration that his mental health status has an impact on how the court or the jury may view his statements with regard to voluntariness, you are also making observations or clinical conclusions about different aspects of his mental health. Is that right?
Yes.
So, on the page 4 of 5, you specifically note, quote, anxiety, significant and improved. Depression, significant and improved. Suicidality, not significant. Patient symptom reports appear questionable, unquote. When you say patient symptom reports appear questionable, what does that reference?
So,
Sorry, where were you referencing on the document?
It's on page 4 or 5. Come on, keep up.
under assessment.
Page 4 or 5? Thank you.
Yes. So that's a checkbox. So I'd have to
That's me.
reference.
That's me.
I'm sorry. Yes.
So that's a checkbox. So I'd have to reference the body of my note to see why I would check that. It just looks like his affect was all over the place that day, from crying to smiling. He also mentioned memory lapses and already said that he might not remember the following day's dates. He was tangential, and again, he was just sharing various information with little prompting from me.
But when you add, excuse me, where the hell is this damn thing? Quote, patient symptom report appears questionable, end quote. Are you questioning?
Yes. Whether it's genuine.
Okay. And you continue to make these observations about him
Yes.
throughout April and May. Is that correct?
Yes.
And so when he's behaving, let me wrote it down here. Bizarrely, it's that a patient symptom report that you're questioning.
Yes.
In fact, over state would move to admit Exhibit 12.
Any objection?
No.
All right, without objection, then 12 is admitted.
Okay. In fact, over the course of the period of time, you make statements that you have concerns that he is feigning symptoms. Do you not?
At times, yes.
And in many of those reports, it would say psychotic symptoms unclear or not present, correct?
Yes.
And in reviewing the reports, I found only one that says psychotic symptoms are clear. Does that sound inconsistent with your observations of Mr. Allen?
So I don't know if that would be closer to the date where he received the injection.
It is.
And at that point, we decided that the situational psychosis diagnosis best explained what we were observing.
Okay. We'll come back to that and how it was addressed. Let's talk about a couple more reports. I just want to read to you part of one on April 7th that you prepared, and it says that he inquired. Excuse me. Let me get a sip of Dr. Pepper, please. Excuse me. You're prepared. It says that he inquired from the writer about whether he was confessing to things and asked what he confessed to. And you informed him and told him it was not in his best interest and likely against the advice of his attorneys to continue to verbalize his claims of guilt, as the information could be passed on by other incarcerated individuals to their families or the media. Is that correct?
Yes.
Okay. And under the clinical observations that day, you said, quote, Allen appears to be more blatantly feigning symptoms of confusion and memory loss and purposefully behaving in a bizarre manner. Would that be based on his verbalizing a lack of memory and then being oriented to person, place, time, and situation on the same day?
Yes.
Okay. There was some discussion about him being allowed to go to rec, even when he was on suicide watch, and you tried to provide that for him. Is that correct?
Yes.
But there was a specific date on April 12, 22, where a note indicates that despite wanting to give him rec, you then had to withhold it because he was refusing to come in from rec. Do you recall that happening?
I mean, if I wrote that down, that's what happened.
Okay, so his behavior at that point was affecting his restriction, not necessarily that he wasn't being permitted.
Right. I mean, it would give custody a problem. They'd have to do things to get him back in a cell, and nobody wants to go through that cell.
Okay, so now there were times when you were present for him making statements about his crime, some of which were very specific, and it was not in your out-of-cell cubicle, correct? For example, when Dr. Martin was asking him if he would accept medication.
Right.
Do you recall that?
I'd need more context for that
Sure.
encounter.
So let me show you what's marked as State's Exhibit 13.
Okay.
Does that refresh your memory?
Yes.
And so even on that day, you were not certain whether it was psychosis or feigning behavior. Is that correct?
Correct.
State would move to admit Exhibit 13.
No objection.
All right, without objection, 13 is admitted.
Now, this is around the time he receives an involuntary injection, correct?
It looks like it. Was that the one that said we were trying to let him know that was going to happen?
Yes.
Yes.
So you offered him to take the injection. Dr. Martin was there, is that correct?
Yes.
And there would have been some nursing staff in the room.
Yes, I mean, he wouldn't get the injection in his cell, so they would have to remove him and take him to another area.
Okay, but he was in a situation of being moved by staff, being video recorded, and he was making statements about his crime, and he was being asked if he wanted medication when he declined, which he declined.
Yes.
Okay, and then a meeting occurred, is that correct, for approval of
Yes.
involuntary medication?
Yes.
And so the next day he received that injection.
Most likely the same day or the next day.
Okay, if the record indicates it was Haldol, are you familiar with that being the course of treatment?
Yeah, that sounds right.
And since you're a psychologist and not a psychiatrist, I don't want to ask you a question outside of your professional expertise, but you are familiar with Haldol being used in a situation such as this, where someone is behaving bizarrely and having difficulty in confinement.
Yes, almost always.
Okay, what impact did you observe Haldol having on Mr. Allen?
If I'm remembering correctly, I still don't think he was sleeping very much. Afterwards, I think then he got an extra oral Haldol to take at night.
And did the Haldol have a positive impact or a negative impact on his ability to communicate with you in sessions and work toward better mental health?
There were definitely days where it was not much, the engagement, like at all. He may have been over-medicated, but eventually things got better.
Well, the logs would indicate that he slept for a couple of days. That's that what you mean by over-medicated?
Well, yes and no. I wasn't thinking about the times when he would come in and not have much to say or just not having any interaction.
Okay, so if he declined interaction, you might have thought that came from Haldol.
Possibly.
It certainly made him sleep.
Yes.
Would that be fair to say?
Not initially, but yes, later.
Okay, if I indicated to you that the suicide companion logs indicated he slept quite a lot for the next couple of days, do you have any reason to dispute that?
My only concern would be that Mr. Allen would say that he was just laying there, so I don't know how they would be able to distinguish between laying there and sleeping.
Okay, with regard to his medication, it is your understanding that he received Prozac, which was the same medication he was receiving for his depression prior to admission at Westville?
Yes.
And did you see any significant changes in his medication?
With the exception of the additional Haldol at one point, I guess he wasn't sleeping. I don't remember any other changes. I think he just stayed on the Prozac.
And would he refuse medication? Do you have any knowledge of that?
It's possible. I don't recall anything significant where he would just never take it, but there are probably some days here and there where he wouldn't.
Okay, how much interaction did you have with Dr. Martin?
Dr. Martin would come to our site maybe once a week, so I'd see him once a week.
And would you and he consult with one another about Mr. Allen, or was that not necessary?
We did talk about Mr. Allen. Again, Dr. Martin would be with the larger group as well, and I would attend those MDT meetings.
Okay.
As the prescriber, obviously, but I tried to give him updates too, like especially when Mr. Allen was complaining about his sleep.
Other than Mr. Allen refusing medication sporadically, was there a change in prescribed medication that was intended to induce him to give statements?
I don't think so.
Did you observe Mr. Allen to improve after the Haldol injections started? I know you said that they were weekly, I think you said.
I don't think they were weekly. He did improve, and eventually he was just taken off the Haldol injection. It was pretty quick.
Okay, so did Mr. Allen had a period of time that he was refusing meals, would you agree, and lost significant weight?
To the best of some of these things I don't remember too much in detail. Yes, but he didn't want to miss more than 4 because then he'd start getting tracked by central office.
Okay. Did you have conversations with him about the reasoning for his missed meals?
Yeah, I want to say it was something about controlling his circumstances and even just losing weight and getting healthier.
Oh. And when he came in, I believe he was described as obese, correct?
Yes.
And when he engaged in this practice of fasting or skipping meals, then did you ever see him at a weight that was concerning?
I think he got to a healthy weight, but then when during that April time period, he really wasn't eating much. I don't know if they were able to track it. If things were being thrown into the toilet, they wouldn't know one way or the other how much he ate. That's when he lost a lot more weight.
And then he stabilized.
And then he regained the weight.
Okay. In fact, did he seem to be rather pleased with himself that he had lost weight? Like, I've never gotten to this weight before. I'm pretty happy with myself.
I don't remember.
Okay, I'll show you States Exhibit 14 appears to be your report for May 2nd, 23. In your report for May 2nd, Mr. Allen is communicating quite a lot that particular day, is he not?
Yeah, he had a lot to say that day.
In fact, you make reference to writing your report and putting it in categories of concerns or topics you wanted to talk about.
Yes.
And in that
Yes.
particular report, does he talk about why he would not kill himself but also make reference to committing the murders that he charged with. Paragraph entitled Death, Suicidality, and Murder.
He's saying that other incarcerated individuals are telling him to kill himself. Is it okay to kill myself, is what he said. He stated he did not want to die. When asked how he would kill himself, he stated he would climb up on the sink. He quote, I killed myself by killing my entire family and best friends. I'm not going to kill myself. I'm too much of a coward, end quote.
You also put in a metaphor, like after the phrase.
Because, I mean, he didn't literally kill his family and his best friends, but yeah.
So you were interpreting that to be a metaphor.
Yes.
You also note on page 3 of 5 under additional clinical observations that he does not appear, page 4 of 5, that his anxiety is significant and his depression is significant, but impulse control, psychotic symptoms, and manic or mania behavior are not significant, correct?
Correct.
I'm going to show you what's marked as State's Exhibit 15. The state would move to admit 14 she previously testified to.
Any objection?
No, ma'am.
All right, without objection. I'm sorry.
Without objection, 14 is admitted.
Oh my God. My apologies, Your Honor.
Okay.
Got a little bit ahead of myself. Are you familiar with that document?
Yes.
And that is a MDT.
It is.
Report prepared by you, is it not?
It is.
And the only thing I want to ask you about this is, on this particular document that's dated May 2nd, 3 p.m., you note psychosis appears to have remitted. Is that accurate?
Yes.
This would be a collective conclusion from that meeting?
Yes.
State would move to admit Exhibit 15.
Any objection?
To 15?
Yes.
You mind if I just take another quick look at that, just because I don't have a copy?
Yeah, sure.
Kind of just took a brief look.
Is there any objection?
No, ma'am.
All right, without objection, 15 is admitted.
Can we go off the record for 10 seconds?
Yeah, you got about 10 seconds.
Okay.
Can't stay off the record.
We have
We are
that
currently
exhibit.
off the record.
Do we have that Exhibit 15 somewhere?
No,
we don't have any of them yet.
We don't have
Okay.
any of these exhibits.
Okay. I mean, this is from the pretrial hearing. I realize we don't have the trial, but this is the MDT committee things where the attorney is going to be in there, and she didn't want to go deep into the exhibit, what was said or who was there, but just make a note of that. We can go back on the record.
Okay. You're back on the record.
Next, show you what's marked as State's Exhibit 16. Did you have a chance to review that?
Yes.
Okay, and that is for the date of, what date is that report?
May 3rd.
May 3rd. Okay, on May 3rd, again, you're seeing Mr. Allen in the counselor cubicle. So that's confidential, correct?
Yes.
Okay, and on this particular day, Mr. Allen asked for your assistance to call his wife. Is that correct?
Yes.
How do you assist him, if at all?
We were able to obtain a cordless phone, figure out the phone number list, and assist with dialing all the numbers.
Okay, and then you make reference that he didn't get to talk to his wife, did he, on that particular day?
I guess not. Oh, yeah. She did not answer.
Okay, at this point, maybe you don't recall, did Mr. Allen not have his tablet?
Right. That would have been the reason why he couldn't reach her on the tablet.
Okay, because he didn't have one. Because it was broken?
Broken.
Okay. And this is during the waiting period of getting a new one, is that right?
Yes.
And did you help facilitate him getting a new one with the warden?
I think he got one on the very last day before he went to Wabash. So, yeah, it just took a minute.
If
Really?
reports would indicate he had a tablet access even within like a week, do you recall that?
Oh, well, now I don't know what I'm thinking of.
Okay. Is it possible it was broken twice?
I don't know.
Okay. Don't
No,
remember. Don't remember. Okay, we'll move on.
it's possible, but
On this particular day, you start with he moves on to telling his story, and you document with including quotation marks to some extent the details on his day on what appears to be the day of the crime. Do you agree?
yes,
And again, that was from you taking detailed notes and then putting them into the medical record system. Is that correct?
yes,
Did you ask Mr. Allen to tell you about the allegations?
no,
And I know I only pointed out a couple of times where you told him not to talk about his crime.
right.
Or did you feel like it was clear to him that it wasn't a good idea for him to talk about it?
I think he was aware.
Okay, you indicate in a clinical observations that although he was confused about Easter and whether it already happened or not, that aside from that, he presented as more organized that he had been since his placement on suicide watch. Do you agree with that?
Yes,
Move to admit 16, Your Honor.
No objection.
All
All right, without objection, 16 is admitted.
During this time when he was struggling and confessing, was he also talking about a transfer to Logansport State Hospital?
he was.
And you had multiple conversations with him about that?
He brought it up a few times.
And you actually referred him to counsel, correct? You said, talk to your attorneys about it?
Right, yes.
Okay. Did you also document it as potential secondary gain for which he might be misbehaving or acting up or having psychotic symptoms?
Yeah, that was another thought.
Okay, it's very possible,
Yes,
just as possible as being psychotic.
yes.
Show you what's been marked as State Exhibit 17. It's your notes from 5/10 of 23.
Yes, Mr. Rosie. We're at
We're at
17.
17, right?
Yeah. Have you had a chance to review that one?
Yes,
Okay, on that particular day, you see him out of cell as well, correct?
yes,
And the arrangements are made for a cordless phone again.
yes,
And you assist him with contacting his wife again. Is that right?
yes,
On this particular day, he does reach her.
yes.
And you step out of the room
Right.
to give him privacy. And upon coming back in, what happens?
He said he wanted to call back to tell his wife he did it. And then he said to me, I want you to hear this so you can understand.
Okay, did he proceed to call his wife again?
Yes,
And did he confess to her regarding the heinous crime that he's charged with?
yes,
And from only seeing one side of the interaction with his wife, do you express an opinion about how she received that information?
I thought she,
Judge, may I ask a preliminary question?
Yes.
Did you talk to his wife?
no,
Okay, did he tell you what her reaction was to any of this?
he made a statement.
Okay, all right, I'll withdraw.
I'm sorry.
The statement was she doesn't believe me.
He makes other statements in addition to that are contained in your report, correct?
Yes,
And then in conclusion, under assessment, you note psychotic symptoms are not significant. He's responding to treatment he's compliant with treatment. Is that correct also?
Yes.
Move to admit 17, Your Honor.
No objection.
All right, without objection, 17's admitted.
I'd like to talk about the potential stressors that relate to the diagnosis, the brief psychotic disorder with related stressors. One of them was the conditions of being confined as a person with no criminal history, correct?
Correct.
Some others that we discussed in deposition, as I recall, and I guess I'm asking if you recall these as well, so correct me if I'm wrong, is that he was either not communicating with his family or couldn't communicate with them.
Right. So when
Because he felt they didn't want him to.
Yeah, I think he went back and forth with different reasons, but yeah, the lack of being able to communicate with them consistently.
Did it coincide with him making confessions to the crime and the difficulty that creates?
I don't know.
Okay. Did he also express that he didn't feel like he had enough communication with his attorneys and that was a related stressor?
He had mentioned that.
Did he also express that he couldn't choose God over family? You recall that?
I'm sure he said it if I wrote it down. I'm not sure how to interpret that one right now.
Okay, I'll ask it another way. Mr. Allen had a period of time where he wanted to confess and he was confessing to a lot of people. Would you agree?
Yes.
Not just you, but to door companions, right?
Yes.
In the presence of Dr. Martin, even though he wasn't asked about his crime.
Yes.
To his wife, in your presence.
Yes.
During movement within the jail while being recorded, you were aware of that?
I think so.
Okay. Did he talk with you about how finding God was impacting his dealing with making confessions? Did he talk to you about that?
Finding God was something that seemed to comfort him.
Did he express that he wanted to make things right?
Yes.
And did he say, I want to make things right by being honest?
I don't know. I don't know if he said that.
Did your personal interest in this case from an entertainment standpoint negatively impact the services you provided to Mr. Annell?
I don't believe so.
Did your curiosity about Keegan Klein have a negative impact on the services you provided to Mr. Allen?
No, they're unrelated.
Did you write down confession statements that he didn't say because you had a personal interest in the outcome of this case?
No.
Did you believe that entering your notes into the document management system that's secure is the best way to keep those records safe?
I think so, but I'll look into this.
Off the record. Good God. 5 softballs in a row. It strikes out with that one. Back on the record, the conditions of his confinement, except for a constant watch or close watch, did they remain the same outside of those changes with regard to whether he had his own clothing or suicide smock, whether he was on constant versus close?
Yeah, it was all pretty much the same thing. He was going to live in that location. That wasn't going to change.
Okay.
It was just about a different points in time, what he was allowed to have in there versus not.
And so once he went through that period of brief psychosis with relaxed stresses, the rest of his time there was very much like the time before.
Yes.
April.
Almost, not quite, I feel like.
Okay. How was it different?
There was still some residual symptoms, maybe, particularly he mentioned the memory issues, but then there were days where he did seem like more like himself.
Okay, but he also tapered off on participating in sessions with you, did he not?
I believe so. We also expanded the amount of people he could see, so he could see a master's level therapist and a bachelor's level therapist, whether during rounds or those were usually rounds, but just to have other people to talk to since we couldn't provide any other outlet in that way.
Okay.
But I'd still check on him.
The social media posts you made that you were presented with,
Yes.
that was specifically asking you what channels you preferred for watching on YouTube. Is that correct?
Yes.
And did you ever post anything about the facts of this case on Mr. Allen?
No.
I'd pass the witness.
Mr. Rosie?
You agree you shouldn't have posted at all.
Are you asking?
Yeah, you should not have been posting at all, should you?
No.
And you should have not been following his case for entertainment purposes while you were treating him, should you?
I don't know. I don't think it affects, knowing about a case does not affect how we treat a person.
Okay, but would you do it again? Would you do it the same way?
No, I wouldn't do it the same way.
You'd separate your personal stuff from your professional stuff, right?
Yes.
There were some questions early on about you taking notes and how you were memorializing them. Just want to make sure I'm clear about that. Your session notes were destroyed. We've already acknowledged that, right?
Yes.
Those could have been given to Internal Affairs and secured, right?
It's nothing.
That'd be one way. I'm sorry, go ahead.
It could be something we can do. It's never been done.
Do you ever give anything else to Internal Affairs to secure?
I usually pass along letters, things maybe threatening towards us or other people, but not necessarily notes that we write.
All right. How often do you get log sheets from the warden?
What kind of log sheets?
The door sheets from the guards when the guards filled them out.
They keep those on the pods, so I'd have to actually go there and seek them out myself.
But did the warden ever direct those to you to maintain for him?
No. Us turning in, so if you're talking about the companion sheets.
No, I'm talking about the guard sheets, but I'll ask you about the companion sheets as well.
Okay, so the guard sheets will be. Are you asking about things like where they're noting, like shower, rec, things like that? Or are you just like their rounds when they watch him?
Fair enough. Let me withdraw the question and try to be a little bit clearer. We've all acknowledged here today that there were guards that were that were assigned to Rick's cell that were completing these log sheets, right?
Yes.
Did you process any of those?
If he was on suicide watch, if it was any of the time periods where he was on suicide watch, those would go to his medical record. So we'd obtain them and put them in his medical record. If they were during a time where he was off suicide watch and was more administratively watched, because that's what they wanted, I'd give them to the unit team manager.
So you processed them in both occasions?
Um.
Well, the first occasion they went directly to the medical file, right?
Yeah.
But you're saying in the second circumstance, when he was not on suicide watch, they went to the unit team.
The unit team manager, because I recall her having a binder where she was keeping them.
Who's that? Is that Miss Cornett?
Yes.
Do you know what she did with them?
I don't know.
Did the warden himself ever ask you to secure records regarding Rick Allen for him?
No.
Him being the warden?
No.
Okay.
They moved them to medical records.
With respect to Exhibit 9, number 9, this is the consent that was signed down at RDC. Are you generally familiar with this document?
Yes,
Okay. Do you agree? I'm sorry, may I approach?
You may.
Do you agree that the scope of the consent that's referenced on this document pertains to basically things that would happen at the prison,
yes.
right? Like,
Uh-oh.
Am I the only one who can't hear Mr. Rosie?
I don't believe I did either.
Okay. Making sure it's not my connection. Sleuthy, I think we lost your connection for a hot second. We'll go off the record while we figure out this tech issue. So she'll probably just have to reconnect.
So we're off the record and waiting for her to pop back on. Oh, there she is.
Yeah,
can you
let's see.
hear me?
Yep, we can hear you now. Okay.
It's like my phone has to fuck up every couple hours. Okay, so
Okay, we're going back on the record. We are at line 20, where you're saying if you can approach, and I said you may. And then so 22.
okay. So do you agree that the scope of the consent that's referenced on this document pertains to basically things that would happen at the prison,
Yes,
right? Like if he tells you somebody's going to commit suicide, you got to disclose that, right?
right,
Or if he tells you he's going to commit suicide,
right.
you got to disclose it, right?
Yes,
If somebody's dealing drugs, you said this earlier,
right.
you got to disclose it. It doesn't say anything about the statute relating to a homicide case.
No,
If somebody comes to you, a patient comes to you and says, "Hey, I know something about a murder," that's not referenced.
no.
It actually also says that, or it makes the reference here in the middle of the page, that group settings are the best mode of treatment or intervention. Do you see that?
Yes,
That's an accurate statement when it comes to therapy.
we've tried to do a lot of them in prison. It's rough though.
Rick Allen never had any group therapy, did he?
It's impossible in the way that he's housed.
Okay, it would be impossible to just take him out of the cell down to a therapeutic environment and let him sit and talk to some humans.
I think it would compromise his safety.
Have you seen all the handcuffs that they put on him and shackles?
Other people, if he was just like in an open area with other incarcerated individuals,
Are you aware of any threats on his life when he was there?
people shouted whatever they shouted.
Well, the people in confinement next to him, right?
Yes,
Telling him to kill himself,
yes,
calling him a baby killer.
yes,
Okay. Are you aware of any reports or anyone threatening his safety?
no,
The last thing I need to note here is where it says progress notes regarding your attendance level, participation, and treatment progress will be entered into your health record, right?
yes.
They were actually destroyed, weren't they?
So,
The progress notes.
so that just pertains to the notes that we put into the medical records, the electronic.
Well, don't you consider the notes that you're preparing progress notes when you're sitting there in the therapeutic session?
Yes.
Well, so, I mean, again, oh, wait, okay.
Well, so, I mean, again, I can look into this
Well, it's too late because they're gone, right?
in terms of do we need to change the process?
Okay.
Because that's not how we're doing it.
Thank you for that. And then with regard to the questions, there's exhibit number 10. I'm directing your attention to exhibit number 10. You may recall that Ms. Steiner asked you about the fact that you instructed him not to talk to others about his case. Do you recall her asking you about that?
Yes.
But you actually
Uh-oh. Come back. Uh-oh, Sleuthy.
I have two.
All right, 1 second. We'll go back off the record of reading while we wait for this tech issue. Yeah, she's gone. Hi, Asin. We're like so close to the end, too. Let me switch the banner. So since we're waiting for her to join back on, there she is. I'll let you guys know when this live is done. When this, I don't know, when this live is over, I'm going to be on Cryptex's channel. So if one of the mods that's in chat could get that link and drop it in chat, that'd be great, because that's where I'm heading when we're done reading the transcripts.
No, it's a beautiful fucking sunny day. It's just choosing to not cooperate. Okay.
Okay, hold on. We're
Did you hear me go like 7 through
no,
10?
you're on line number 7. That's where you stopped.
Okay. Thank you for that. And then with regard to the questions, there's exhibit number 10. I'm directing your attention to exhibit number 10. You may recall that Ms. Diener asked you about the fact that you instructed him not to talk to others about his case. Do you recall her asking you about that?
Yes.
But you actually talked to him about his case as it relates to what you were learning on social media, didn't you?
I mentioned a couple of things, yeah.
So you didn't follow your own instructions, right?
It was helpful information.
You talked, Ms. Diener asked you about some of these daily or weekly visits that would occur at his cell block, right?
Yes.
You know what I'm talking about when you do the routine checkups?
Yeah.
Those are like 10 to 15, 20-second visits, aren't they?
Depends on the person.
That would be normal, wouldn't it?
Depends on if the person engages with you. Some guys will just say they're fine and they expect you to go away. Some may talk for a few minutes.
Okay. You've never had, well, let me ask you this. Are all those people that would visit with Rick, the master's level specialists, and are they basically just talking with him through the same crack in the door that you were talking with him through?
Yes.
Okay, very informal encounters. Agreed?
Yeah. Yeah.
Ms. Diener asked you about these companions and what information that they were communicating outside of their job responsibilities. Do you understand that? Do you remember that line of questioning?
Can you clarify?
I will, thank you. Ms. Diener, do you recall her asking you some questions about what kind of things these companions were saying out in public?
So,
Do you remember those questions being asked?
yes.
Okay, you don't know what information they were communicating, do you?
The only thing that I know that came out pretty quickly was somebody made a YouTube video from his, I guess he called it someone on his phone, and he's like, hey, this guy's here, and it went out on YouTube.
They were disseminating this stuff to the whole world, right?
Yes.
And so ultimately, this was part of the reason, in your opinion, as to why the companions were pulled, right? That's what you told me in the deposition.
Well, I said too that it was when he had the discovery materials, we didn't want people to view those materials.
Right, but you also told me it was the other reason.
Yeah.
Because whatever they were communicating wasn't right?
Right.
Or it wasn't appropriate is a better way of putting it.
Right.
When someone is confined in solitary confinement like Mr. Allen is it unusual for inmates in those circumstances to say things to try to get the attention of staff?
It's not unusual.
I mean, that's one of the ways that they can get some interaction, right?
Yes.
So you say something crazy and the staff will give you some attention.
Yes.
Correct? These are all kind of the nuances of living in this restricted environment. Is that accurate?
Yeah, accurate.
Ms. Diener briefly asked you about the circumstances in Wabash Valley with the cage down there. Do you recall that?
I do.
I saw that cage, and it reminded me of the cage in Silence of the Lambs. You know what I'm talking about?
Diener? I object, Judge. His reference to his own impression about the cage is not relevant.
Fair.
Sustained.
I'll withdraw the question.
That was pretty good. I
Thank
liked
you.
it. I'll go with that.
Did the cage remind you of the cage that was in Silence of the Lambs?
I don't remember that movie.
Sorry.
Sleuthy, did we lose Sleuthy again? Oh, Sleuthy. Sleuthy, bring it home.
Line 11. Okay. I just don't remember the movie. I could believe I never saw it, but anybody who saw that movie, you can't not remember it.
I don't know how anybody could have not seen that movie.
Dude, what is happening?
I don't know. It's like it doesn't want you to finish this at all.
Okay, so did that cage remind you of the cage that was in Silence of the Lambs?
I don't remember that movie.
Okay, thank you. Miss Diener questioned you about this early April, I think she said April 3rd circumstance where Rick got his discovery. Do you recall that?
Yes.
You acknowledged that you told me earlier that he actually was starting to communicate some mental health issues and wasn't feeling right in the head even back into March, right?
It's possible if I wrote that, yes.
That's what he told you, didn't he?
Yes.
Okay. So it was weeks before he got the discovery, right?
Yes.
And you don't know what was in that discovery, do you?
No.
You have no idea what was on those papers, right?
I have no idea.
And he had been communicating with his lawyers for 6 months up to that point, hadn't he?
I guess. I don't know unless he tells.
Are you aware that we visited with him at Westville?
Yes.
Okay. The statements, I'm directing your attention to number 11, exhibit 11 and 12. And I'll bring them up if I need to, but these reference activities that occurred on April 4th of 2023 between you and Mr. Allen and April 5th. Does that sound generally accurate?
Yes.
Want me to read those questions until she pops back in?
Yeah, hold on one second.
Now I hear you. Can you hear me at all?
I can hear you. Yeah, we can hear you again.
Yeah, perfect. Perfect.
Okay, so
Go ahead.
I don't know why you're like on my normal. Let me hold on.
Hey, Rockstar. We're just having some tech issues. We're trying to get through the last like 10 pages of this. And it's like it doesn't want us to ever end.
Okay, so I unplugged the charger that I was using and I plugged in a different charger and I'm like wondering if that's what it is. So if it doesn't happen again very quickly, then we'll know that that was the problem.
Okay. All right.
So where did you hear me?
Yes.
So am I on 12?
Yes.
This would have been during the time period when there was.
Yeah, line 7.
12. Keep going. This is like fucking torture. We have less than 8 pages. I know, poor Sleuthy.
Let me read a few questions till she pops
Okay.
back.
You want to
So I
start
think
it?
we're
You
at
want
line
to
12.
start it? Okay, go ahead. And then we'll just go
Line
from there.
12.
So Right now, Diener is going to
This would
read
have
for
been,
Rosie.
yeah, this would have been during the time period when there was later a determination that he could have been suffering from psychosis, right?
Yes.
And when somebody says brief psychotic episodes, that's something that can happen on and off over a period of time, right?
Okay, now I'm on my computer. So let's see if this continues to happen on my computer.
Okay, you're on line 17. Or no, I'm on line 17. No, you're on
You
line
sound
15. You sound
Where do you
better.
Okay, and when somebody
you
says
sound better. So read line 7.
line
15.
15.
Yeah, do that.
Okay, when somebody says brief psychotic episodes, that's something that can happen on and off over a period of time, right?
It would likely end up being a different diagnosis.
Okay, but can it happen on and off over a period of time?
I would agree that it'd probably be a different diagnosis.
Very good.
Can those types of symptoms occur? Yes. And fluctuate over time? Yes.
You continued to give him Haldol shots all the way into almost June, right?
I'm not sure.
Those are basically tranquilizers, right?
Yes.
That's kind of a street term.
Yes.
And if somebody was just faking something and they were, doing it to get attention, you wouldn't need to tranquilize them to get them to stop, right?
I mean, that's the psychiatrist. I mean, sometimes it does help just calm them down, so it's used, but again, we don't use them very often.
Did you use those on Rick because he was faking this stuff?
At that point in time, he was deteriorating in terms of taking care of himself, he wasn't able to communicate with us. He wasn't sleeping, so it was just interfering with every aspect of his life.
Literally beating his head into the wall time and time and time again over long periods of time, wasn't he?
Yes.
Running from one end of his cell back and smashing his head into his cell door. Is that what was going on?
I personally didn't observe it.
You heard that, didn't you?
I heard it.
And he had all the physical signs of it, didn't he?
Yes.
His entire face and head was completely bruised, wasn't it?
Yes.
And then he started eating his own feces.
Yes.
That's why you gave him Haldol, isn't it?
Yes.
With regard to his feigning symptoms, do you acknowledge that that's actually a circumstance which you can test someone for in the course of your psychiatric testing process, right?
You can.
There's actually ways to kind of cross-check whether or not somebody's being authentic or genuine about their behaviors.
Right.
You didn't do any of that in this case, right?
We don't have the materials to do it.
You told me, actually, occasionally some interns might bring in some documents.
We don't have interns.
You don't even have interns, right? Just crayons and pencils, right?
Yes.
With regard to the Prozac, or the Haldol, I'm sorry, he was taking Prozac, right?
Yes.
And are there different, like a generic form of that? Was there different kinds of, Prozac's a trade name, right?
Yes.
I'm sorry if it's a trade name, like a company.
It is, yeah.
Was he taking Prozac or was it some other? Do you know?
I don't know.
Like a generic version?
Sometimes they can do both, switch them off. I don't know.
Okay, so does that happen at the prison?
It happens.
Okay, could it have happened with him?
Could have.
He said he lost weight. What was it, 30 or 40 pounds in a few months?
It was pretty significant.
When you say he was obese, he wasn't obese to the point where he was dysfunctional when he came, right?
No.
I mean, he's a short man, right?
Yes.
And do you acknowledge that it's just the chart puts him at obese in terms of where his weight was?
Yes.
Did you have any real concerns about his weight when he was admitted to the facility?
No.
And then with the tablet, you said it took a minute to get him a new one, right?
The way that I remember it.
And when you say took a minute, That's kind of a casual phrase for it took quite a long time, right?
Probably.
Months.
It could be months.
He talked to you about going to Logansport State Hospital, right?
He did.
Is there anything surprising about somebody trying to or wanting to get out of a situation like that?
To be in a more comfortable situation, I believe he also thought maybe family visits would take place.
He could get closer to the people that he loved.
Yes.
You mentioned that there were residual symptoms that he was experiencing, even beyond what I recall was the July or June,
Uh-huh.
all the way into the fall, right, of 2023?
Yes, it was quite.
You could, I'm assuming, is it accurate to say that these residual symptoms are a product of being traumatized at some point, of experiencing trauma?
Could be.
I have nothing further.
Ms. Diener?
No other questions.
All right. Thank you, doctor.
All right.
You may sit down.
She's
I
released from her
I was half asleep. No other questions.
You may step down as she released from her subpoena.
Agree.
You're free to go. You're released from your
Agree.
subpoena.
Thank you.
All right. Well, all the state exhibits.
Judge, with regard to her testimony, I'd like to ask that all the state's exhibit be sealed because of the nature of the document.
Okay, so let's just seal all of those documents submitted by the state, and then whatever the defendant submits as well, any additional witnesses. So that is the end of her testimony. We gave the thumb drive. I'm just looking to see if there's anything after her testimony.
I went through all of that. There's nothing in there. Yeah, there's nothing of substance in there.
Nothing of substance in here. The thumb drive that marked CC with an appendix. It's the calls, which we have some of the calls. We did not get all of the calls.
I think I feel like I have all the calls.
No, we didn't. They didn't play all the calls that they at trial.
Oh yeah, not all of them. Yeah, just the ones from trial. Never mind.
Yeah, so yeah, we don't. All the ones that are in this compilation that they're giving to her during the 3-day hearing.
Right.
We don't have all of those. Okay, so final thoughts on Dr. Monica Walla's testimony from the 3-day hearing. I mean, I can't wait. I know Sleuthie, you said you're going to sit down and compare this to her testimony from the trial, which I think is fantastic because there's so much.
I just have two quick thoughts and thought I'd let you and Sleuthie say, go over what your thoughts were. My two quick thoughts were, she didn't seem like overly evasive to me. She didn't seem, I know what people's thoughts and feelings are about her in reference to being part of this, this institutional treatment. I think I've seen people use the term she was a cog. I think that's true. She didn't seem to be super good for the state, or try to be super bad or evasive for the when defense was questioning. I think part of that's because she just kind of laid it all out in the depot, and she knew, very well prepared by somebody, the critical questions that were asked of her about her own survival, the guidelines. She answered those like I would expect, but then at some point, Rosie's asking her about medical records, and she said, "Well, I have to look into that." And he goes, "Well, it's too late now. You destroyed them." And she said, "Well, I meant whether we should take another look at that." I mean, to me,
So
she
it's funny
acknowledged
because I remember when we were like after this
her
3-day hearing
problems
had like
specifically
transpired.
on social media. And
Delay. I think we have a delay. I was saying, so like after the 3-day hearings actually happened, I remember not being so anti Walla Walla. Like I kind of remember going like, she obviously did some shit wrong, and you know, but I was not fully on board with it. She was part of this whole entire thing to get him, you know, convicted of a murder. Like I wasn't that far yet. I was just like, okay, she's obviously not the, you know, the sharpest tool in the shed kind of thing. And then I remember, like, as we got closer to trial and more documents and stuff started coming out about Walla and then the trial, and I was like, I absolutely believe that she is 100% a state actor in this thing. And what
Agreed.
she's doing behind the scenes is way more than what the public is aware of. And people in chat can agree or disagree with me. I don't care. My thought process is there is information that only Dr. Walla had that became public long before it should have been. Long before a hearing, long before a trial, that people on social media knew. The only way that they could know that is from Dr. Walla. So if Dr. Walla told somebody else who told them, by all means, that's fine too. Or she
But she's
told them
still running her
directly.
mouth to people, though.
She's running her mouth to somebody. And that was when I was like, all right, I'm no more benefit of the doubt. Because I was like, she went up there. She admitted that she screwed up about the Keegan Klein stuff. She admitted that she probably shouldn't have done it. Like, I was like giving her still like a little bit of leeway. But nope.
I personally think that she was speaking to people on social media directly, considering she was in all the Facebook groups and shit like that and listened to everybody's coverage and whatnot.
Yes.
And I think she provided them information. I think they had discussions, and then she took those discussions back to her sessions with Rick Allen, because who would have any proof that she's not saying to him, well, were you going to sexually assault them? Which was somebody else's theory. And say, well, were you going to sexually assault them and you got like interrupted by something? Like, there's no recordings of these sessions. Nobody would ever know that she said that to him. And then all they know of these sessions is what she's writing down. And not even what she's writing down, just what she's typing into the system.
Right. So the alternative then is to say somebody like it went in and hacked her, and that's how they got the information from her. That just doesn't make sense, because it's apparently she's getting rid of all of her notes, so nobody has access to those, right?
Not even her.
Right.
And the state was very, very careful not to go into everything. Diener just used he confessed, that did a couple of examples, and then confessed to many people, but stuff about white van, they were clearly holding stuff back. And my comment about she appeared to be forthcoming, I'm talking about just limited to the
both sides.
limited to the four corners of the transcript. And so your point's well taken, Teresa, that other stuff started coming out, and not as forthcoming as she appeared. But again, I'm seeing that the state asked very pointed questions. There's no doubt in my mind that they, as you're allowed to do, met with her, went through the testimony, probably told her, look, don't sweat this, don't sweat these guidelines thing. It's because from our perspective, the prosecutors I'm talking about, it's no harm, no foul. Yeah, you probably shouldn't have done it. Big deal. Preserving probably the same conversation they had with Proctor, but it wasn't going to be near as easy with Proctor. That just admit you were an idiot, that had nothing to do with your investigation. I'm just trying to analogize across cases people are familiar with, but No,
Well,
I
see,
agree on.
they had his text messages. I think it would be damning if there was a way to subpoena Walla's conversations, not
Like
only
like
her,
when the DOJ got involved with Karen Reed and got all the personal fucking messages.
yep,
That's what Delphi needs with
like
a Walla and a Nick and a Holman and a Liggett and a Mullen.
exactly, like not even just her social media communications, which I think would be important, but also communications, like, for example, to Jerry Holman's emails from her work computer to Jerry Holman, phone calls back and forth, things like that.
See, you guys have these great ideas, and
Just
again, I'll
yeah,
say it
all they are
again:
though.
a civil rights suit would have allowed
Right.
subpoenas to get phone data, things like that. And then remember, in the Karen Reed case, normally in criminal defense, we don't get that stuff. You ask the court, yeah, we want their personal cell phone, and they're like, I'm not giving you that unless you've got something solid,
Right.
and you don't get that. But when there's you know, you just don't get that type of information, those text messages, unless there's an investigation by another agency and you get
Right. But
access like they did in Reed. The only way you get that type of stuff is in a civil case. You might still have a fight about it, but it's just more routinely handed over in this day and age. They may run it through a screening process that gets submitted to the judge, and the judge makes a determination. But and then, as you both know, that stuff has a shelf life.
correct. That's exactly
Uh,
what I was getting ready
if
to
you
say.
switch phones,
Yep.
yeah.
Well, and even just their retention periods. How long? Like every day that goes by, they're losing information.
Which was Michael's point with regard to this, with regard to data in general, with regard to phones and phone data, um, and he explained, yeah, you can't proceed with the post conviction stuff, where you can do discovery until after the direct appeal. But there are some things we can do. One of which is I can draft a complaint. I won't be able to handle it, but at least I can draft it and get it in within the statute of limitations, and then we can find some attorneys to pursue it. And then, we don't need to go into all the drama in that, but it clearly is not because of money. You saw on a case that they clearly won for multiple prisoners that the total settlement was $500,000 divided by 30, 40 people. That on those types of cases, is a money loser for the attorney. Yeah, that's unfortunate. Teresa, I know you probably have more comments. Do you know what the next day is? We're going to be doing a reading. I heard Monday we're doing trial testimony. Are we doing anything tomorrow?
As of right now, I'm not doing anything tomorrow, but Sleuthy and I were talking, or that you were on here before we started this live, about is there a bunch that we, because of the in-betweens of testimony, and we only had testimony from, a few people last year when we got the original part of this transcript. So how much did we miss that they were putting in for like offer of proof and stuff like that? So we may do something like maybe just like Sleuthy and I go through and just read whatever we're missing, just so we have it like on the criminality record. And then Monday we're starting with day one of trial. So the morning we'll be doing opening statements and then go straight from there. I think that I started writing it all down. So there's 5 witnesses on the first day.
Okay. Well, I'll be
So,
ready for that. And then I have the Vordaer transcript. I know you commented that kind of hesitant to go through all of that. I don't really
well,
think you
so
do, but what I'm going to do is
All Eyes
highlight
went
it.
through. All Eyes was going through, which is amazing, and breaking it down based on what would be important for the ones who actually ended up on the jury that deliberated. So she did all of that. So I think that's
Good.
all Eyes is in chat. She'll correct me if I'm wrong on exactly how she did it, but that was what I was perceiving as we were doing this live. So I think it'll be easier to go through and see like the important part of the jury voir dire so that we can just nail the ones who ended up on the jury versus looking at the thing in its entirety. There may be more important stuff in there, but if you're going to go through and highlight it too, that's great. That works too.
Well,
I
wanted to
may
pick
not
out,
do that.
yeah,
I may not do that until
wanted to pick out
later,
two
though.
or three that I thought were well done so that people, not necessarily people who made the jury, but it could also be people who didn't make it and why. And it's going to be based on pretrial publicity, what they were asking. And I'll try and find two or three good ones that if there's kind of a lull thing and you need filler a week from now or however long this takes to read,
well, so there's a couple
something
of days
and we can
that she lets the court out early, and that's kind of when I was planning on either just doing some things that were like learning and comparing to what we know now, what we knew then, things like that, and just having more conversation because like there's a few days that she lets everybody out at like by noon. So we'll only have like testimony of like 3 people, and then so the rest will just be us talking. But some days are full days of witness back to back, which is exhausting for those of us who are on here all day. You know what I mean? Like, so I don't know. But the plan right now is Monday. That is the only solid thing I have is Monday, starting with opening statements and going from there. Do you guys, Sleuthy, do you have anything you want to add to that? Because I know you're switching loads. Never mind. You don't have anything you want to add to that.
Well,
that's kind of my plan right now.
Both of you, now that you've heard the testimony from like day 1 and 2 or whatever days it was in this, and I know you didn't have some of these transcripts from before. You had some of them and we read through them, but the ones that you didn't have before that got read so far, what's the most surprising thing that you learned, or what witness was the most surprising that nobody had before?
I don't know if I would say surprising, but I really enjoyed actually having to read Todd, like getting to read Todd Click's testimony and how direct he was. Like he wasn't backing down from anything when it came to what Nick had to say or what anybody had to say. It was like, this is what happened. This is how it was. And I think it was kind of, for me, that was eye-opening on the fact that we always kind of assumed on why he got arrested pretty shortly before trial. I feel like Todd Click's was the most eye-opening, for me anyway. And then there was a couple things that came out with Vito on the stand that I either have forgotten or I never knew. And that kind of was like, wait a minute, what? The fact that he had a 40 cal that he no longer had and nobody seemed to give a shit about that. I thought that was quite weird. Just some of that stuff with Vito. I would say those two were probably the best two that I think. I don't know. Sleuthy would have to answer for her, but I know she was changing her laundry real quick. I mean, I enjoyed listening to Murphy. You could feel like, how much he had invested in all of it. I do think that there's a lot that Ferenczi would have had to offer, but obviously he's no longer with us either.
Has there come a time yet in what you have read so far that there was a sidebar? And if there was it transcribed?
I haven't read anything for trial yet. But I do think we have sidebars just from peeking through it, but we haven't done anything with trial. And so there's obviously, we've only done hearings so far because I wanted.
I keep forgetting, even in hearings outside the presence of the jury, Judge Cannoni, when they would still have sidebars.
Yeah, she just sidebarred. She sidebarred everything. But like Sleuthy had, which I think was a way better plan, when like we got the transcripts, I was very like just like, oh my god, I was so overwhelmed with just everything that I was going to have to do with the check and the people and controlling and blah blah blah. So I was like, okay. But she was like, no, we're going to finish the hearings because we need to know what was said prior to reading the trial to know what she didn't let in and what could have been changed for the trial. So it was better to do it this way. And so that's why I'm like, if there is a bunch of stuff that's important that we need to go through from the 3-day
No,
hearing.
I absolutely agree. Bob and Allie, when they did the openings, Bob said, well, Allie's like, I think we should do the pretrial stuff. And law nerds, of course, but and they kind of had an impromptu vote. And of course, most people wanted to hear the openings. But no, it's good that you're doing this, I feel, because how she rules on these motions lays the foundation for everything that goes forward.
Right.
Case in points, Perlmutter. And she testified on one of these 3 days and
Right.
did not testify in the trial. And so it gives a better sense. I'm glad you all did it this way, because you'll constantly have to be referring back to this when people have questions about, well, why didn't the defense do this or, do that? And it's like, well, they couldn't. Now, you have a pretty knowledgeable chat group of which I'm a member, a proud member of your chat group.
Aww.
Very, very smart, but they're in tune to that. And they'll use things like the judge tied, their hands behind their back and things like that. But so I'm very glad y'all did these hearings before, because this is where you win and lose at trial. Not always, but
I do think a lot of these losses set up Rosie and Baldwin to like almost walk in. I wouldn't say defeated because I still think they fought. I just feel like they didn't fight the way that they actually intended to fight based on all these pretrial losses.
When the briefs get filed eventually in the direct appeal, no matter how good trial counsel does, when you're separate direct appeal counsel, one of the things you have to look for, because it's an automatic grounds to get a new trial, is ineffective assistance of counsel. The attorney's messed up, and that's just part of it. And when you're reviewing the transcripts and hindsight, and everybody has legal experience, whether as a lawyer or not, but all of them have commented that they might have done something a little bit different here or there, whether it raises to the level of ineffective assistance of counsel. But yeah, it's there's been some comments about, well, they should have done this. And it's like, there just becomes a point where you get kicked in the teeth 10 times. You're not going to go up for an 11th. And you've got to maintain the credibility in front of the jury. But, those are all really, really good points. But yeah, all
and
of
some
the
of it, you have to put yourself in like the position of the person during that moment. And, just because like we're seeing something later, I mean, they call it Monday morning quarterbacking, obviously, but I mean, it's like you don't know how you're feeling in that bit of the moment or what your thought process is. And I can say, like, when I walk away from something, I'm like, shit, I wish I would have said that, or I should have done this, or I said something along those lines.
Yeah, I don't know too many trial lawyers that with a big witness don't have all different levels, but even top levels, that's a key witness, and they do a brilliant cross-examination, and never had an occasion where they didn't say, oh man, I forgot to ask. And it didn't even matter. It's just one of those things. But Monday morning quarterbacking is what appellate lawyers do, and trial lawyers understand that's part of their job. And, we don't take that personal, or most don't. It's, especially when you have a client that you feel is factually innocent. You want them to find anything and everything they possibly can, whether it's something we could have done or shouldn't have done, whether it's the state not producing everything they should, whether the judge had a clear, gross, and an egregious error, whatever the case may be. But
Right.
it is Monday morning quarterbacking. There's no doubt about it. But yeah, I'm really, really glad getting the hearings. It's not as juicy as the witnesses, but I think people are already seeing, or the comments I saw from the first day, that because the reports about how Walla's testimony was, you'd have to get it from the people who were there, and not everybody saw it the same way. And between Bob and Harvard lawyer, can't remember her name, I'm so sorry, Andrea, whoever else was doing daily reports, you saw even a difference in the interpretation. I think they all tried to be accurate, but there's a bias in terms of what you feel is important. And you have that in everyday life. Things jump out at you, and it's because, oh yeah, I know this, and that's why that's stuck in my brain. And so, except Andre kind of got 99% everything. It didn't matter, but there were some things I was thinking back. I don't remember too much, but I do remember on Walla's testimony, some people were commenting, it was a big nothing burger for the defense. And then others, it just increased the outrage about Walla's conduct. And then some of the things were revealed, like the eating of the feces and slamming his head in the wall. And, and so two people looking at the same thing, and what they come away with, that, it's nothing. They were trying to help him, and on top of it, he lost weight. I remember those comments. I'm going, wow, were you guys in the same hearing, or what the hell? And so I know you tried to get whatever you could back at the time, and that was enlightening. But Walla Walla's, and I'm going to go back and watch Quicks again. But it's great you started this whole thing and kicked it off, and then going through the trial and the testimony is going to be enlightening for a lot of people. So I think it's a really good exercise.
It is interesting now how many people want to have transcripts versus just buying into the narrative being sold on social media. So I'm glad we started that a long time ago, because that was really what was happening, was people were just buying into it, and we were like, let's just fucking get them and see if we can correct whatever's going on.
Yeah. So publicly, I'm just going to say, I know you've commented and hadn't made a final decision what you're going to do, but I don't want mine to be returned. I want you to keep it in a fund that you have ready. I mean, you might have to get the sidebar ones for Karen Reed. There may be,
we'd like to get those
exhibits, but thank you for mentioning that in your little quick spot that you did when you found out you're going to get them free. But no, please hold on to mine, and I know you guys will use it really wisely. Sleuthy, are you back? I see the mute switch went off.
Yeah, I can hear you. You want to give your final thoughts, and then I'm going to say goodbye and head over to Cryptex, because I think he's waiting on me.
Not really. I mean, I agree with everything you guys said. I obviously want to go back and look at things for myself, but off the top of my head, the things that I found most interesting of what we read yesterday and today would be, like Teresa said, they'll just say I'm agreeing with you because it's you, but would be veto, in Click, and I feel like they really twisted Click's testimony. And I also feel like remember when we got the half statement from Murder Sheet of Todd Click? Do you remember that?
Yep.
And then it like
Oh
came
yeah.
out that there was a whole nother half. I think his intentions, even with that statement, became more clear when you heard his testimony, because he was obviously saying, I don't agree that they were killed in an Odinist ritual, but I do believe that there was an Odinist ritual occurring. And he was very specific and very direct about what he thought happened. With,
hmm
with one or both of the girls making fun of what's happening, and in a fit of rage, someone hauled off and killed one of them, and then had to kill the other one, had to kill Abby because she was a witness. It would also make sense on the treatment of both of them.
Yeah.
And so I did like that. And then Vito, I was pissed off about the gun. We already know this. And with Walla, I felt like reading, I still hate her. I hate her guts.
I know.
But reading her testimony, I feel like she's like, I partially want to say incompetent. The other part of me wants to just say that like anybody could provide notes and say that they're her notes. And I feel like she would just go along with like, well, if it's written in there, then I wrote that, then that's what happened. And didn't remember much of what was written, which
When
which
she's the one who not only wrote it, but then also put it in the computer. Like you wrote it and put it in the computer. Like I have a bad memory, and that kind of stuff. When you're repeating it, it starts to stick a little bit more.
100%. That's why I make the spreadsheets. But
Right.
like I feel like, and I also feel like there were questions that weren't asked of her, which I would have liked, but maybe they do ask in the trial. I can't remember, and I look forward to reading it. But like the whole thing with her going down to Wabash, like why? Why did nobody say why? Why did you take it upon yourself to go see him at Wabash? What did you talk to him about at Wabash?
Yeah.
Or are
And
you in
Even the thing
communication
wasn't
with
with
him?
the
it
even the
wasn't in
thing
the
you were
visitors
saying
page.
about electronic medical records, those are logged every time you log in. The precise
Every
date,
keystroke
time
we
that
make,
she
every time
entered
we
that,
click.
where's the logs on? It was asked. Diener came back and asked. You entered this stuff the the same day while it was fresh in your mind, trying to dispel this thing that the handwritten notes aren't kept. Um, but yeah, there are a lot of questions just by virtue of your knowledge of how this stuff is done. I mean, it's done in
Yeah.
all areas of medical practice. You write down written notes, except a lot of doctors now, they wheel around a laptop on a stand and have a PA or a RN
Or
or
me.
some sort of assistant typing this stuff in. And the doctor says, negative Babinski,
Yeah,
positive Romberg. Yeah.
that's
But
me. And so
why when Walla went to Wabash did she not see him in the cell that the attorneys saw him in? Where did she see him at?
don't know. Oh, well, I don't know for sure.
His
I'm
own wife
thinking it
couldn't visit
was
him there.
I'm
Yeah. Was the
thinking
Wabash thing, was she even on duty or was it for entertainment to follow him after he moved?
I also think they don't do a good job distinguishing, and again, maybe at trial it's different. I have not read it. I haven't read any of the trial transcripts yet, but I don't think they made a very good distinction between like what specific things did you actually observe? What specific things did he actually say to you that you heard with your own ears versus what are you picking up from the guards? What are you picking up from the suicide companions? Like whose notes are you going off of? Where did you hear this? Like some of this is a lot of hearsay on top of hearsay on top of hearsay that she's
Mm-hmm.
putting in the medical record, and then they're acting like she has this knowledge and she doesn't. But
Mm-hmm.
to your answer about Wabash, I'm not entirely sure, but I feel like that's where the conversation came up, where they brought up this cage. Was that like she went and talked to him and he was in this cage? It looked like it was part of like, if you've ever seen Orange is the New Black, they keep like the pantry in like, it's like a cinder block pantry, and the door is like a cage. It sounded like that's what it was. But I think they did show us pictures
They
of
did,
the
but
one in Wabash.
Yeah, Nick went and actually took pictures, or Nick's people did, I guess, right?
I think. I
Yeah,
don't
I
remember.
remember that back from Emotion. But she said she didn't see him in that. She never saw that cage. It was in the kitchen. Yeah, she never saw it when she went to Wabash. So where the hell did she talk to him at?
I just want to know. I don't know, but I want to know why too. Why the fuck did you go all the way to Wabash to talk to him? Why was that so important? Like, and for me, like, I'll back my documentation, right? Like, if I'm not going to remember every single patient that I saw every single day, like hers is a little bit different because she's basically seeing the same people over and over and over and over and over again.
Mm-hmm.
These people are here, they live there, they're there all the time. Whereas
Mm-hmm.
I see different patients literally every day. And so I'm not going to remember every single patient that I saw every single day, what they said to me, and be able to look at my notes and be like, oh yes,
Right.
I remember this conversation. I mean, some of them I might, but I too would say, okay, if I wrote it down, then that's what happened. I'm confident in my notes. However, the only way I'm doing that is if I'm getting a log printed out from Epic that says I am the only one that touched that person's chart and those notes. And they absolutely are able to tell, like, so in Epic there's tabs. They're able to tell what tabs you click in, what notes you open, literally everything in your login. And so unless I could verify that I was the only one touching that shit, I would not be testifying in court to the stuff that they're showing me, regardless if it has my name on it. And I don't think that Walla has that level of not, well, I guess sort of professionalism, but there's a different word that I'm looking for too.
Yeah,
Well,
she seemed really informal and really loose with some of her answers, and
She didn't know like anything with regard to like her code of ethics or anything.
no, but she was just like, this is how we all do it, so it's okay. And like he even brought that up. He's like, so if everybody does it, that's fine. Like that doesn't make it okay.
Like you said, you know how stupid that sounds, right, bitch?
Like somebody has to be accountable for following these rules that are actually put in place. Like where are
Also,
the
who are
people
you to
coming
say
into
that everybody does it? How the fuck do you know everybody does it?
Well, like, yeah. Now
Everybody
everybody's in
where?
trouble because you're over here just saying everybody does something you don't even know that they all do.
Yeah.
Ugh.
Yeah, she's gross.
Yeah. Agreed. All right. So anything else you guys want to add? Otherwise, I'm gonna wrap
No,
this up.
I'm gonna come watch you. I'm gonna pick up a thing of food because I haven't ate since my kid left. Because once he leaves, I have like no need to cook or do anything. So
Get some food. I need some food too.
yeah, and I'm gonna put an Olaplex mask on my hair, and I'm gonna listen to you over on Cryptex.
Okay.
yeah, I'm going to pop over there too. I hope they put the link in.
Mods, can
And
you drop the link one more time?
I was gonna say I know they had,
They
but
have
maybe
been.
do
Yeah.
it before we leave.
and the only thing I had to say is thank you both for having me again.
Oh shit.
I
No way. Thank you.
always
Thank you
enjoy
for
it.
helping.
And I know you're not here anymore, but thank you also. It makes for long days, so I appreciate you guys. Thank you so much. Sleuthy as always. I thank you. We wouldn't even have half of this even happening if it wasn't for you. So
I forced you to do
I
things
was
to you.
told, full disclosure, no ad libbing, and I couldn't help myself a few times. But the only substantive ad lib is the word hyenas. She never said heinous, but I just had to.
I need to figure out what the fuck is happening with my phone, why it was doing that, because we have like a whole ass trial to read, and I don't have time for these
yeah,
problems with the phone.
I agree.
I had the problems when we first started, had to come back out and in, and it's the Wi-Fi that the mesh that we have set up here, and
Yeah, but I tried it on Wi-Fi, off Wi-Fi. I turned off my Bluetooth just in case it was connecting to something somewhere, and that was then cutting me off. I
uh,
unplugged. Remember, I told you I switched the chargers because I thought maybe the charger was fucking it up.
I'm gonna say sunspots.
I
I
did
don't know.
everything but smash my phone. Like that was
Don't do that.
Well, I didn't try to turn it back off. I didn't try to turn it off and turn it back on. That probably would have helped, but. All right, let's go to Cryptex.
Let's
Are
go
you
to
going there
Cryptex.
right now?
I am. I'm going into the StreamYard link right now. As soon as I get off here.
I just
right.
didn't want any breaks. Okay.
Yeah, go take your break.
No, I don't want a break. I want to start right now.
All right, everybody. Thank you guys so much for hanging out with us. As always, I know you have 1,000 other places you could spend your time, and
Been
you
kicked
choose
out of most of those.
time here with us, and we love you for it. We'll see you on Cryptex, and then we'll also see you back here maybe tomorrow. Don't count on that. Just count on Monday morning for opening statements. That's kind of what I want to. That's kind of where we're at right now. Because I don't know if we're going to get everything else together in time, so we'll see. Maybe tomorrow, but absolutely Monday morning. And I'll see you on Cryptex in just a few.
Okay.
Bye.
Love you. Bye.
Love you. Bye.
Do you dare to follow me down? Head into the unknown. Down the rabbit hole. Where it stops, no one knows. We're going down. We're going Do you dare to follow me down? Head into the unknown.